that, but because you didn't encrypt it, every day that you didn't encrypt it, because you were supposed to, under the security rule, every day you didn't have that policy in place or that method in place, that could be a separate violation. So the penalties can add up incredibly fast. Now, it's a mandatory fine of at least $10,000. That's if you correct it within 30 days. If you fail to correct it within 30 days because you just don't like HIPAA or the horse you ride in on, then in that situation, it's a mandatory fine of at least $50,000 per violation. That's the bad news. The good news is if you don't act with willful neglect and you correct the situation within 30 days, you can avoid HIPAA penalties. That is an affirmative defense. The lesson there for all of us is to make sure that you do not act with willful neglect and that you correct the situation within 30 days. If you do that, you can avoid HIPAA fines. Now, look at some of the settlements this past year. You know, for those of you who thought that it was going to be a kinder, gentler nation under President Trump, not necessarily, at least from the OCR. You look at the penalties that have come down. Look at a couple of them. A couple of them deal with insufficient risk analysis and no finalized security policy. Millions of dollars in penalties. Why? Because they're not complying with the security rule. The security rule compliance, that's where your big ticket exposure is, because if you've got a violation of the security rule, you've got multiple people who are affected, so multiple violations. It's really important that you focus on your risk analysis and complete your security rule compliance. That's what Matt's going to talk about a little bit later. Look at some of the other things that are going on. An entity got hit up with a $31,000 fine because they didn't have a business associate agreement in place. So over this past year, the government has really been going after entities for failing to have business associate agreements in place. So we're going to talk about that. Another one that came down. Lost unencrypted PDAs. A couple of those came out to that. If you have electronic data on your PDAs, on your laptops or USBs, you got to make sure that you encrypt that stuff. If you don't and you lose it, that is presumed to be a HIPAA violation, which means you're going to have to self-report that stuff, and it can result in significant fines and the penalties. Another one that just came out, we got the first case on the failure to timely report a breach. A company had to pay $475,000. So if you do have a breach of unsecured protected health information, you've got to do a timely breach report. If you don't, you can get hit up with those fines or penalties. We'll talk about each one of those situations. Now, for those of you who are thinking, we're in Idaho, we're protected. The government would never come after us here in Idaho. No, au contraire. The first case that the government went after for somebody for a breach of less than 500 patients was actually here in Idaho. It was a hospice that was up in North. They had to pay $50,000. So you need to make sure that you take this stuff seriously. So to avoid those HIPAA penalties, generally, you can avoid the HIPAA civil penalties if you do the following. If you have the required policies and the safeguards in place, if you execute valid business associate agreements, you train your personnel concerning those things, if there is a potential problem, that you respond immediately to mitigate and correct that situation. And if there's a breach that has to be reported, you need to timely report that. If you do those things, I can almost guarantee you that there's not going to be willful neglect. And even though there's a HIPAA violation, you can avoid the HIPAA fines and the penalties. Now, it's possible that you can get hit up with other consequences too, including a suit by an individual may sue you if you use their information improperly, but you can avoid the HIPAA fines or penalties that are imposed by the Office for Civil Rights. All right. Let's talk about entities that are covered by HIPAA. I presume all of you are healthcare providers. Healthcare providers are covered by HIPAA, but not all healthcare providers. It's only healthcare providers who engage in certain electronic transactions. And I have had situations in the last couple of years where people have come forward. They said, oh, we've got to comply with HIPAA, blah, 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 blah. But I ask them, well, are you engaging in any of these electronic transactions? Usually things like submissions to insurance companies and things like that electronically. If you are a purely paper office, then HIPAA doesn't apply to you. You still have to comply with the state laws, but HIPAA doesn't apply to you. Remember, HIPAA also applies to not only healthcare providers, but health plans that are administered by a third party or have 50 or more participants. So remember, HIPAA not only applies to you in your capacity as a healthcare provider, but if you have a health plan that is administered by a third party or has 50 or more participants, that health plan also has to comply with HIPAA. It's got to have its own policies and things like that. The government really hasn't focused on those types of things, but just remember that if they decide to come after you for that, that you could be liable for the HIPAA violations. In the wake of the omnibus rule, HIPAA also now applies directly to business associates of covered entities. We'll talk about that later. HIPAA applies to protected health information. I get this issue sometimes. Well, we only disclosed the patient's name. We didn't disclose anything else. Didn't tell anything about the treatment. We just, mentioned that the person was a patient of ours. Is that a violation of HIPAA? Yeah. Just their name is a violation. HIPAA applies to any individually identifiable health information, which is information that could be used to identify the individual that concerns their health, healthcare, or payment for their healthcare created or received by a covered entity in its capacity as a healthcare provider, and it's maintained in any form or medium. It's oral, it's photos, it doesn't matter, Snapchat, whatever it might be. All of that stuff is protected health information. Now, conversely, HIPAA doesn't apply if you've gone out and you sucked out all of that identifiable information. You have de-identified it. If you have done that, then HIPAA no longer applies and you can use it, disclose it, it doesn't matter, at least for purposes of HIPAA. I like this slide because it gives you the list. The regulation gives you the list of the stuff that you need to suck out in order to de-identify the information. That list also tells you, okay, remember these are identifiers, right? If you're disclosing this type of information, you're disclosing identifiable information. Some people don't think about it. Well, we didn't include their name. We included their account number. It's okay as long as we include their account number, right? As long as we don't include their name. No. If it's any identifiable information, including any of those things that are up there. Now, remember that HIPAA only applies to the information that you maintain in your capacity as a healthcare provider. If you have employment records, for example, HIPAA doesn't apply to employment records. It may apply to the group plan, health plan records, but not information that you maintain in your capacity, not as a healthcare provider, but simply as an employer. With that said, beware using patient information for employment purposes, especially if you're a hospital. We'll have sometimes, this case arises, especially in a lot of the rural areas. There's only one hospital in town. The hospital employs a bunch of people. Those employees come to the hospital to get their health care. Sometimes you have situations where those hospitals want to use that information from that patient's file. Maybe they've got a nurse who goes in there for drug treatment or for an overdose or things like that, and they want to use that for their employment-related decisions. Generally, you cannot do that unless you've got the patient relationship. You need to segregate those functions, okay? If you are providing care to that patient in your capacity as a healthcare provider, that information has to remain confidential, and you can only use it or disclose it as allowed by HIPAA, which generally means that you would need an authorization to use that information for employment-related purposes. What kind of actions does HIPAA apply to? Well, obviously, it applies to any unauthorized disclosure outside your organization, but it also applies to any unauthorized use or improper use within your organization. You can't access this stuff if you don't have a need to know. So let's talk about the use and disclosure rules. Generally, they're summarized as follows. First, don't access if you don't need to know. Second, don't disclose unless you fit within an exception or have the patient's authorization. And you've got to implement reasonable safeguards. Let's talk about those rules. First, and most importantly, HIPAA allows you to use or disclose protected health information for purposes of treatment, payment, or healthcare operations without the patient's authorization. You don't need the patient's authorization. You don't need the patient's consent to use or disclose protected health information as long as it's for treatment, payment, or healthcare operations. Now, the rule differs a little bit depending on whether it's you're using or disclosing it for your own treatment, payment, or healthcare operations or for another's treatment, payment, or healthcare operations. You can always use it or disclose it for your own treatment or healthcare operations, treatment, payment, or healthcare operations. But what happens if you get a call from another physician's office that they want some of that information for their treatment, payment, or healthcare operations? You can disclose it to another provider for their treatment, payment, but only certain healthcare operations, okay? So if they wanted to conduct their own quality assurance or those types of things, you can, as long as you both had a treatment relationship with that patient. Some additional considerations have to be satisfied. So you have to remember, okay, who's asking it? Is it for our treatment, payment, or healthcare operations, or is it for somebody else's? There's an exception for psychotherapy notes. We'll talk about that in just a little bit. Now, even though HIPAA allows you to use or disclose the information without the patient's consent for treatment, payment, or healthcare operations, HIPAA also says, hey, but if you're really into privacy and you go to the patient and you tell the patient, we're only going to use or disclose this information with your consent, then you got to live by that. So you may, if you go to the patient and you tell them, hey, we're only going to disclose the information to the people you tell us to disclose, well, now you have agreed to with the patient that you're not going to disclose it to others without their consent, including for purposes of treatment, payment, or healthcare operations. So what you may be doing is you may be limiting or restricting your right to use the information for treatment, payment, or healthcare operations. Don't agree to those things, okay? That's just going to increase your potential liability. You don't have to agree to restrictions on the use or disclosure for treatment, payment, or healthcare operations. But if you do, you got to comply with that. My advice, don't agree to that. And be careful of situations where you may have done that intentionally. Maybe on your registration form, when the patient comes in, you will say something like, identify all of those people to whom we may make your disclosure. Give us the list of the people. Well, the problem with that is what you may be saying is, we're not going to disclose it to anybody else. And I'll bet you those people are not putting down the collection agency. Okay? So you want to make sure that you don't ask for that information, or if you do ask for that information, ask that for the list of the patients, that you at least have some kind of disclaimer or make it clear that you are not waiving your right to make disclosures to other people. Okay? All right. So that's the first exception. For treatment, payment, or healthcare operations, you don't need the patient's consent. The next exception, HIPAA allows you to use or disclose protected health information to family members or others involved in the patient's care or payment for their care, generally, so long as you gave the patient a chance to agree or object, and the patient didn't agree or didn't object, and you otherwise determined that the disclosure is reasonable. Okay? This is the situation where, wife calls in to find out what's going on with the husband. Okay? Well, is that disclosure for treatment, payment, and healthcare operations? It might be, but if not, then this would still allow you to go ahead and make the disclosure so long as you gave the patient a chance to agree or object and the patient didn't object, or if the patient didn't have a chance because the patient was incapacitated or something like that, that you determine that it's in the patient's best interest to go ahead and make the disclosure. Now, even in that situation, though, you can only disclose the information that's relevant to that person's involvement in the patient's health care or payment for their health care. So you have to limit the scope of that disclosure. It used to be that that did not apply when the person died. They changed the rule, so it makes it a lot easier now. So you've got a deceased patient. Family member comes in, wants their information. You now no longer have to confirm that they are the personal representative under the estate. Instead, you can rely on this to determine whether or not, okay, did the patient indicate they don't want me to disclose that information to this person? If not, then you can go ahead and make that disclosure as long as you satisfy this criteria. Okay, that's the second exception. Third exception, for those entities that maintain a facility directory, HIPAA allows you to go ahead and use or disclose certain information for purposes of a facility directory. So if somebody comes up to find out where the patient is in the hospital, you can have your pink lady tell them where they are, but only if you satisfy these criteria. You may disclose it if you gave the patient notice and that you were going to use their information for purposes of the facility directory and the patient didn't object. Most of you, all of you should be providing the patient with a notice of their privacy practices, right? In that notice of privacy practices, it should have a section in there that says that we will use or disclose your information for purposes of the facility directory unless you object. If you don't object, then we will go ahead and use it. If you do object, then tell us by notifying us in this manner. As long as you've done that, at least arguably, you have given them the required notice, and you can use the information for the facility directory. But you can only use that information if the person shows up and asks for the patient's information by name. So they can't just show up and say, hey, do you have somebody here who has brown hair and who appeared with a gunshot wound, or something like that, okay? For the purposes of this exception, the person who wants that information, they have to ask for the patient by name. Now, if the patient's unable to agree or object, you may use or disclose the limited information for purposes of the facility directory if it's consistent with the patient's prior expressed wishes and you otherwise think it's appropriate under the circumstances, it's in the patient's best interest. HIPAA will, in response to this particular exception, HIPAA only allows you to disclose certain limited information, namely their name, which I always thought was kind of odd because they've got to ask for the patient by name anyway to get it, so what good does that do? But you can only disclose their name, their location in the facility, and their general condition, like, critical, dead, something like that, okay? You can't disclose more specific information. If it's clergy, then they don't have to ask for the patient by name, and you can also disclose their religion, but that doesn't apply to others. So that is another exception. This is the exception that's most commonly used for media. If you get a call from media and they say, hey, did you just, we understand there was a terrible accident out on I-15. Have you gotten any patients from that particular accident? Can you disclose the information? No, why? That's right, because they didn't ask for the patient by name, okay? What if they call up and say, hey, we just saw on the news that Representative Stanger was taken into your place for, drug treatment. We'd like you to comment on that. Can you provide that information? Well, theoretically, maybe you could do it for facility purposes, although I question whether or not that's for facility purposes. But in order to do it, it would still have to be a situation where they ask for the patient by name, that the patient, Representative Stanger in that particular case, had an opportunity to agree or object, or if he didn't have the opportunity, that disclosure is consistent with the patient's prior expressed wishes. If I've never been there before and you have no idea whether or not that's consistent, then how can you ever disclose that information? The bottom line is, exception is used a lot with media, but its scope is really limited. So be careful that you can assume that you can give that information to the media. Yes? Yeah, so the question is, on that particular exception for facility directory purposes, disclosures for facility directory purposes, it says that you can only make the disclosure if it's consistent with the patient's prior expressed wishes. Okay, so the question is, what about if a patient comes in, they're non-responsive? If they have been to the hospital before, and in that situation they didn't object to being on the facility directory, yeah, in that situation you can go ahead and make it as long as you otherwise stay within the criteria, right? It's consistent with their prior expressed wishes, but you still have to conclude it's in the patient's best interest. And a lot of those disclosures to the media are not going to be in the patient's best interest, okay? What about if the patient had never been there before? Well, it may be difficult to establish that it is consistent with the patient's prior expressed wishes. Okay? Now, you could still rely on the authority of the personal representative in that situation if you want to. But, all right, next exception. HIPAA allows you to go ahead and make a disclosure to the extent the use or disclosure is required by another law. Okay? Note on this one. Two things. First, you need to make sure that if you're making a disclosure that's required by another law, that you limit that disclosure to the scope of that other law. Don't disclose more than is allowed by that other law. In addition, this only applies if the disclosure is required by another law. It doesn't apply if disclosure is only permitted by another law, because in that situation, HIPAA would trump. So we have a specific situation here in Idaho where a legislature amended the statute a little while ago to allow healthcare providers to disclose information to DMV. It allows healthcare providers to disclose information to DMV if they think that a person is an unsafe driver. Well, it only allows the disclosure. It doesn't require it, and therefore HIPAA trumps the Idaho law, and that law is worthless. They should have asked me before they passed the law. Okay. So what are some situations where the law requires the disclosure? Well, here in Idaho, as in most states, you have mandatory disclosures for child abuse or vulnerable adult abuse. You have disclosures for treatment of victims of a crime or treatment of persons because of a firearms injury. Or you've got mental health care providers who have to make disclosures if the person has made a credible threat against a third party, then you've got to go ahead and make disclosures. There are requirements that you disclose certain communicable diseases. The key here is you just make sure that you comply with the requirements of that applicable law. All right, what's the next one? The next one is HIPAA allows you to go ahead and make disclosures to the extent it's necessary to avoid a serious and imminent threat of harm to a particular individual. So you think that this is going to create a big, you think that you've got a patient there who poses a risk of harm to somebody else, you want to go ahead and make the disclosure? Yeah, you can go ahead and do that so long as it's serious and imminent. They don't give us a lot of guidance on that. And if the disclosure is made to a person with the authority to go ahead and do something about it. So you'd call the local police, not necessarily Channel 7, okay? Fortunately, there's a provision in the regulations that specifically says that good faith is presumed in these situations, right? So as long as you're making the disclosure in good faith and good faith is presumed, then you're going to be protected. All right, there's a HIPAA exception that allows you to make disclosure for certain public health activities. There's also an exception that allows you to make disclosures for health oversight activities. These are the ones that allows when the Bureau of Facility Standards to show up at your organization. This allows them to get that information. Or if you get a request from the Board of Medicine or the Board of Nursing, this is the one that allows you to make disclosures that are relevant for that. If you do get those types of requests, make sure that you pull out the regulations and take a look, because there are specific requirements that apply to each one of those. For example, if it's the Board of Nursing that shows up, they can't get the information if the nurse is the patient. So there's limitations that apply. Next, there's an exception that allows you to make disclosures in judicial or administrative proceedings. So let's talk briefly about that, because it comes up quite often. Let's say you've got a situation where you get a court order to disclose the information. If it's an order that's signed by a judge or a magistrate, they are the law. You can always disclose the information pursuant to a court order that's signed by the judge or the magistrate. Okay, they are the law. In fact, if you don't disclose it, then you can be subject to contempt sanctions unless you've taken appropriate steps to file an appropriate objection. So if it's signed by a judge or magistrate, then you can go ahead and do it. Now, quite often you'll get subpoenas, and they're not signed by the judge or the magistrate. They're just signed by a prosecutor, or they're signed by another lawyer. In that situation, the rule's different. Now, that's still a valid subpoena. If you ignore it, you can still get hit up with contempt sanctions, but HIPAA also says, hey, we want to make sure that you go through some additional steps to ensure the patient's rights are protected. And so they said, yeah, you still got to comply, but you can't disclose the information unless you get one of two things. One is satisfactory written assurance from the party that issued the subpoena that they have notified the patient and the time for objections for the subpoena have passed or have been ruled against, or that they've gotten a protective order. So one option is to go to the person that issued the subpoena and get those written assurances. The other option, which is the easier option, is simply for you to notify the patient. You get that subpoena, you notify the patient and tell them, hey, we got this subpoena. We're going to have to respond by such and such a day unless you take steps to quash that subpoena and notify us. If you don't do that, then we're going to go ahead and respond, and, you know, it's on you to go ahead and take the action. That is usually the easiest and safest course, okay? So when you get that subpoena, it's not signed by a judge or a magistrate, just go ahead and send a copy of that to the patient. Tell them, hey, you're going to have to take care of this, otherwise we're going to go ahead and respond, okay? All right. What about if the police show up at your doorstep and they want information? They are the police, so they're entitled to anything they want, right? No, not necessarily. HIPAA still applies even to police. So let's talk about the situation. The first is, well, what if they show up with legal process, with a warrant or an order? Well, again, if it's signed by the judge or a magistrate, they're the law. So you can go ahead and give it. Just make sure that you comply strictly with the scope of that order. Also, if they show up with a grand jury subpoena, even if it's signed by a prosecutor, everything that occurs in a grand jury is protected anyway, and so they already have protections. So as long as it's a grand jury subpoena, you can go ahead and produce the information. If it's an administrative request, they show up, maybe it's the Office of Inspector General with a civil investigatory demand. It's an authorization that's allowed by law. In those situations, you can go ahead and comply if certain criteria are satisfied. Not, however, if the prosecutor just shows up and says, give me some information. That's not enough. Okay. Well, what happens if the law enforcement shows up and they don't have legal process? They're just hot and heavy. They're just after this particular felon or something like that. Well, can you make those disclosures? Well, it's limited. The first is you can make a disclosure as necessary to report a crime that occurs on your premises. So if you've got somebody who has just stolen a bunch of drugs from you, you can go ahead and you can contact the law enforcement as long as it's a crime on the premises. A question? Okay. So the question is, does identity theft apply? Yeah. If they're committing the crime on the premises, assuming that you are the victim of the identity theft, right, that they're trying to get money from you or get your health care by get health care from you because they're forging somebody else's information, then yes. identity theft would apply in that situation. It could be possession of stolen drugs. It could be, you know, theft of a prescription pad, any of that stuff. If the crime occurs on your premises, you can call the police. That makes sense, right? Oh, the patient's in there beating up my staff, but I can't do anything because HIPAA prevents me from calling the police. Okay. The second is if the law enforcement shows up and tells you that they need information in order to track down a suspect, a fugitive, a victim, or a missing person or a witness, okay? HIPAA allows you to go ahead and disclose information, but only certain information, okay? Not everything, but only limited information that would allow them to identify that person. And it's only in response to a law enforcement request. They have to show up and ask for that information, or the commentary also says if they publish like an APB on the news, something like that, then that is a request and you can go ahead and respond, but only limited information. I get the question sometimes, well, police bring in a patient to a particular hospital. They don't want to stay there because they don't want to pay for it, or they just drop the patient off, but they want you to notify them when the patient's discharged. Can you do that? This is a little bit of a gray area. I don't think that you can, because remember the purpose of this is to locate the patient, right? To allow the police to locate the patient. Well, if the police know where the patient is, they're in the facility. They're the one who brought him there. So I don't think that necessarily calling them to tell them when the person's going to be released, that fits within this exception. But it's a little bit of a gray area. I've had disputes with some people. The bottom line, though, I think it would be safer to tell the police, no, we can't do that. You know, you can call in, you can check on the facility directory exception or something like that, but don't expect us just to notify them. If you want us to, then go get a court order that allows us to go ahead and do that. I think that that's the safer thing to do. I doubt that you would get fined, or if you did make that disclosure in response to the police request once they leave the facility, but I don't think that's the better practice. Question? Oh, good question. So you have a situation where there's been a forged prescription. The police are following up on the investigation. They want you to give them the information. Good question. Remember, HIPAA does allow you to report crimes that occurred on the premises, but the purpose of there is to report it, right? Once you've made the report, I'm not sure that you necessarily give them everything. And if the police show up in order to get that information, I think the safest thing to do in that situation is probably to tell them, no, I'll need a warrant or a subpoena in order to get that information, or I'll need you to identify a specific HIPAA exception that would allow us to do that. Now, with that said, I doubt that you would ever be fined, because the report of crime on the premises is a little bit murky. So if that forged prescription occurred and you are the victim of that, it was submitted to you, then I think that it could be argued that that's a crime on the premises. So the question is it valid PHI, just the forged prescription? Yeah, I still think that it is. It's a situation where you rendered health care. You provided the prescription, right, to somebody. It may not have been the person you thought that it was going to be provided to, but I think that you were providing health care when you gave that prescription out to somebody. So I still think that it would probably be considered PHI. There was actually that Texas case that came out, on May 10th, where in that particular situation, it was a situation where somebody did identity theft. They stole a bunch of information, got prescriptions improperly from the hospital. The hospital ended up doing a press release where they disclosed the patient's name, and they got hit up with fines or penalties because of that. And I think that suggests that that was considered health care information in that situation. If it wasn't health information, they shouldn't have got hit up with the fines or the penalties. So. All right. Let's see. There's also a couple of exceptions under this, that if the police show up and they need information about a victim, then you can go ahead and disclose the information as long as the victim agrees. And if the victim can't agree because they're not present or they're incapacitated, then the police have to indicate that this is truly an emergency. They need the information right now, and that it's in the patient's best interest to go ahead and provide that information. Okay, so the question is, what about child abuse situations? So are you talking about a situation where you have to report the child abuse, or the police are investigating child abuse? Okay, so the police, so it's, if you're reporting it, then there's a HIPAA exception that allows you to report it. There's actually two exceptions that allow you to report it because it's a disclosure that's required by law, and also there under the public health exception you can report it. You could also turn over that information to the police under the public health exception. So there's two exceptions that apply to that unique situation for child abuse, also to vulnerable adult abuse. Even if it's the parent who's the alleged abuser, yeah, it doesn't matter for purposes of that. Okay, next one. HIPAA allows you to make the, yeah, question. Right. So I'm going to stop it just long enough so that the people who are off-site understand. So the question is, you've got a situation where you've reported child abuse, and now the police wants to come in and get additional information, or CPS wants to get additional information. And you indicate that in that situation, you normally ask them to confirm their authority to get that additional information without a subpoena or that, and I think that's exactly the right thing to do. Okay. Right. Right. The comment is on a lot of these situations, it allows you to make the disclosure for purposes of reporting, but that doesn't necessarily mean that once you report it that they can get everything. When in doubt, go back and look at the rules, see how broadly the rules can be read, and if there's any doubt, then just tell them that you'll need a warrant or a subpoena in order to get the additional information. I think that's the safest thing to do. All right, HIPAA allows you to go ahead and make disclosures to the extent that, for workers' comp purposes, to the extent that the state law allows you to make those disclosures, okay? In Idaho, our state law not only allows, but requires you to make disclosures if you are treating a workers' comp patient. You've got to disclose the information that's relevant to an occupational injury or disease to the employer's surety manager, fund, or their attorney, and you've got to provide a first copy of the reports to them without charge. Now, sometimes you'll get the situation where the workers' comp attorney or the workers' comp surety not only wants information concerning this particular incident that gave rise, but all their history too. In that situation, I would argue that, well, all that other information is not really relevant to this particular information. We can only disclose the information that's relevant to this particular injury. So you may, in that situation, you may say, okay, we'll give you this information relevant to this, his broken arm on this date, but we're not going to give you all of his past history. There are certain other exceptions. The key here on all of these exceptions is if there's any doubt, go crack the regulations, take a look at them, because there's certain criteria that have to be satisfied before you can make those disclosures in those cases. Or, even better yet, call your privacy officer and let them deal with those situations. All right. So unless you can fit within one of those exceptions that allows you to make the disclosures without the patient's authorization, the general rule is you've got to have the patient's consent or authorization before you can use or disclose their protected health information. Now, it used to be that we would only talk about the patient's HIPAA-compliant health care authorization. In the wake of the omnibus rule, they created this whole new concept of patient's written request, okay? So now you can go ahead and make the disclosures not only if you have a written HIPAA authorization, but also if you have the patient's request to disclose the information to a third party. So under the new rule, in the wake of the omnibus rule, it states that you not only may, but you must provide protected health information that's maintained in the designated record set to a third party if you get a written request by the patient that clearly identifies the designated recipient and where to send the information, and it's signed by the patient. So if the patient comes in and says, I want this information sent to my lawyer, or I want this information sent to my insurance company, or I want this information sent to my mother, you must comply with that. That's part of the patient's right to access, okay? That means as long as you get the written request from the patient that clearly identifies who and where that information goes, and it's signed by the patient, okay? Yeah, Melissa.
When you get those, don't you still have a duty to make sure that it is actually the patient who's requested it?
So the question is, if you get that, do you still have an obligation to verify that they are who they are? Yes, you do have that obligation. We'll come to that in just a minute. An important part on these patient requests for the disclosure to third party, this is treated as part of the patient's right to access. That means that all of those rules that are applicable to the patient's right to access also apply to these patient requests to send their information to a third party. That means that if the patient's requesting it, you've got to respond within 30 days, and also you can only charge a reasonable cost-based fee. The limits that would apply to your disclosure to the patient would also apply to disclosures to third parties pursuant to this written request. There is the verification requirement, as Melissa said. There's also the requirement that you've got to use reasonable safeguards to protect the information, okay? So no longer do you, in fact, you may not ask for the patient's, if the patient comes in and says, I want you to send this information to a third party, you can't say, well, you must fill out this HIPAA authorization. You can't do that. That would be, in the commentary, they specifically say that would be an unreasonable barrier. You can require a written request, but you don't have to require all the additional information that would be in a HIPAA authorization, okay? So that's, Melissa. Okay, so the question is, what happens if you get a request from the attorney's office? It's not coming from the patient, but it's the attorney's office, and they say that. Okay. So the yeah. So the question is, what do you do if you get, you know, these dang lawyers? These lawyers are getting smart now, and they realize that if they ask for the information, you can charge them a reasonable cost-based fee. But if the patient asks, or excuse me, you can charge them basically whatever you want if they're asking for the information. But if the patient requests the information, then you can only charge them a reasonable cost-based fee. So what they're doing is they're going out and they're getting the patient to sign some kind of request to get the information. So it fits now within this exception rather than the HIPAA authorization. And the question is, okay, you get that written document that's signed by the patient. What do you do on that? You go back and you want to verify that that is the patient who really signed that, and then the lawyer gets upset that you're asking for that information. We don't really care what that lawyer thinks, okay, because the commentary, if you read that, the HIPAA guide on access, patient access, it still says that you've got to take reasonable steps to verify that the person is who they say they are. So you could ask for some kind of a confirmation, but they also make it really clear that you shouldn't go to the extent that you're posing an unreasonable barrier to what the patient's trying to access. So, you know, you may call the patient themselves just to verify that the patient is the one who authorized that. You could require something else as long as it's not a reasonable barrier. But I'd go back, and we'll talk about that in a little bit when we're talking about the verification process. Good questions. All right. Now, in contrast to that, if the request is coming in from a third party, not from the patient, but it's coming in from a third party, then the general rule is that you need to get a HIPAA-compliant authorization. That's what we've been dealing with since back in 2003. In order to be a valid HIPAA authorization, it's got to contain certain criteria. In addition, certain uses or disclosures require an authorization, particularly psychotherapy notes, usage or disclosures for marketing, sale of protected health information, research, and some others. Those HIPAA-compliant authorizations cannot be combined with any other document. So you can't have like a HIPAA authorization / consent for treatment, okay? It's got to be separate and apart if you're fitting within this exception. It's got to contain the required elements and certain required statements, and there you go. If it's a HIPAA authorization that's coming, for example, from the life insurance company or some other third party, maybe it's the patient was involved in a car accident and you're getting an authorization from the opposing counsel's attorney in order to provide that information. If it's coming from the third party, then those rules that apply to requests by the patient are off. You don't have to even respond to this. You can respond whenever you feel like it, whenever you get around to it. You're not subject to the 30-day limitation. You can charge them whatever you want to charge them as long as you don't cross the line and begin selling the information like we'll talk about in just a minute. All right, so let's talk about some of those situations where authorization is required. The first is psychotherapy notes. Psychotherapy notes get extra protection. But this is not all mental health records, at least under HIPAA. Okay? It's only psychotherapy notes. Psychotherapy notes are defined as notes that are recorded in any medium by a healthcare provider who is a mental health professional documenting or analyzing the contents of conversation during a private counseling session or a group, joint, or family counseling session and that are separated from the rest of the individual's medical records. Psych notes do not include medication prescription and monitoring, counseling session start times, blah, 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 treatment records, other than the actual notes from that psychotherapy session, that counseling session. For the notes from the psychotherapy session, they're supposed to be segregated from any of the other records, and they get extra protection. You got to have a specific authorization that is specific to the psych notes. You can't turn over psych notes just with a general authorization that applies to all other records. Psych notes have to have a specific authorization for those psych notes. So if you get a request from a plaintiff's lawyer who wants all of the patient's records, including psych notes, you'd need 2 authorizations, one for the psych notes and one for all the other records. A word about employment physicals, drug tests, or IMEs. These are situations where, quite often maybe you're doing drug tests or fitness to return to duty tests for a particular employer. Patient shows up, you do the test. What do? You just automatically send the test results back to the employer. But wait a minute. Can you do that without the patient's authorization? General rule is no. HIPAA still applies to that stuff. Even though you are getting that information for purposes of disclosure, HIPAA still applies to it, which generally means you need the patient's authorization or their written request before you can go ahead and provide that information to the employer. Okay? Now, there is one special rule, though. The general rule is you can't condition authorization, you can't condition your treatment on the authorization. You can't say we're only going to give you, provide this treatment to you unless, we're only going to provide this treatment if you give us an authorization to make the disclosure. General rule is you can't do that. There's an exception, though, if the whole purpose for doing that treatment is to be able to allow you to make the disclosure, then in that situation you can condition the treatment. So if you have the employee that's coming in there for the fitness of duty test, or you have the patient who's coming in for an independent medical exam or for a drug test, those situations, what you want to do is say that, okay, you're here for this test. I will provide it, but only if you give me the written authorization that allows me to make the disclosure. If you're not going to give me the written authorization, then I'm not going to go ahead and do the test, and you can do that. That's how you resolve that situation. Now, if the patient goes ahead and revokes that authorization because they don't like the results of that, you could probably still go ahead and provide the results anyway because you have relied on that authorization in order to go ahead and perform that test, and you will probably be okay in that situation. Okay? So the bottom line is be real careful. A lot of people assume that just if they're coming in for a fitness for duty, then I'm entitled to disclose to the employer. No, you still got to have the patient's written authorization, either the HIPAA authorization or you can get the patient's signed a request to disclose it to a third party. Kim. So the question is, if you are a payer that you're coming in there and doing an audit to determine whether or not you paid appropriately, can you go in there and look at those psychotherapy notes, or do you need additional authorization? Yes, you need additional authorization. Well, actually the payer doesn't need the authorization, but you as the healthcare provider, before you can disclose that information to the payer, you would need to have an additional authorization from the patient. But remember, psychotherapy notes are really specific, and you presumably segregated those from the other notes. You could still provide everything about that counseling session, including start and stop times that you performed it and that. You can still provide all that other stuff that the payer needs in order to make the determination without disclosing psychotherapy notes. So if you're segregating it appropriately and documenting it appropriately, it should never be an issue. But if they really do want to look at the psychotherapy note sessions, they would have to get a separate authorization from the patient in order to make that disclosure. All right, next one, marketing. The general rule here is, hey, if you're going to market a product, you need the patient's authorization, and marketing is very broad. It includes any time you're going out to try to convince somebody else to purchase an item or service or get an item or service, okay? Now, it does not apply, however, to communications that you use to describe a product or service that you guys provide. That's not marketing. When you're telling your patients about things that you provide, that's not marketing. That's treatment or operations, okay? It doesn't apply to disclosures for treatment purposes. It doesn't apply to case management, care coordination, that type of stuff, unless you're getting paid to make that disclosure. If you're getting paid to make that disclosure, then generally you can't, it is considered marketing. So I'm going to jump ahead here just because I have to diagram this because it's a little bit confusing, but this, to me, helps. So general rule is, for marketing, you got to have the patient's written authorization, okay? Marketing is any communication about a product or service that encourages the recipient to purchase or use the product or service. Now, so general rule is, you've got to have authorization for marketing communications. You do not need the patient's authorization if it's a face-to-face communication or you're simply offering a promotional gift of nominal value. Face-to-face communication means face-to-face communication. It's not by fax, it's not by telephone, okay? But if it's face-to-face or promotional gift of nominal value, that's not considered marketing. You don't need authorization. Also, you don't need authorization if the disclosure is for treatment purposes, so you're telling them about something they need for their own treatment, or for your own healthcare operations, or to describe your own products or services, the services that you guys are providing. General rule is, for those things, that's not marketing and you don't need the patient's authorization, unless you're getting financial remuneration to make those disclosures. If you're getting financial remuneration by a third party to make those disclosures, then in that situation, it does turn it into marketing and you would need the patient's written authorization, okay? Just be careful about doing that marketing. I got a call a little while ago from a person that said, hey, we've got these providers that are opening up this other ancillary services. We want to send all of our patients this information concerning these ancillary services from this other imaging center that we're opening. In that situation, I told them that no, generally you can't use your information about your patients to disclose information about this other service if you're not providing that service at that other location. Okay? Beware of those marketing issues. All right, next one. You cannot sell protected health information, okay, without the patient's authorization. And as part of that, you would have to disclose whether you're going to receive remuneration in exchange for the information. Sell a PHI is very broad. It's getting money. It's getting anything else of value in your remuneration in order to exchange that protected health information. It may apply to situations under the commentary that came out on the patient's access. If you have that authorization that allows you to disclose the information and it's really annoying that you got that, or it's a lawyer and you hate lawyers, so we're going to charge them $500 per page in order to disclose that information. The government has said, hey, in that situation, if you're charging more than a reasonable fee for the cost of those records, that is selling information, and you would need the patient's authorization before you could disclose under those circumstances. So be careful of the situations when where you may be selling, you're getting paid in order to make disclosures. There are a bunch of exceptions to what is or is not a sale of information. I'm not going to go through them now. All right, what about fundraising? You're a hospital, you're engaging in your campaign, you want to go out and get information from the patients so that they can, or use or disclose information so that you can go out on your fundraising campaign. Can you do that? Well, the general rule is you need the patient's authorization unless you can satisfy certain criteria. You can disclose information to an institutionally related foundation so long as you gave the patient advance notice and give them options to opt out of getting those types of communications. What about research? HIPAA would allow you to go ahead and use or disclose the information without authorization for most research purposes, but there's certain things that you have to do in order to comply with that. The government has actually issued a really good guidance on research situations. So if you're engaging in research, then make sure that you're familiar with that guidance. All right. We've been talking now for almost an hour on the use and disclosure rules. Just to summarize, general rule is you cannot use or disclose protected health information unless it's for purposes of treatment, payment, or healthcare operations. And for purposes of treatment, payment, or healthcare operations, what do you need? Nothing. You don't need the patient's consent. You don't need their authorization. Unless you've agreed otherwise, don't agree otherwise. Okay. For disclosures to family members and others involved in the patient's healthcare or payment for their healthcare, what do you need? Generally nothing, so long as you've notified the patient, given them a chance to agree or object, and they haven't objected. The disclosure is appropriate under the circumstances, and you limit the disclosure to the scope of that person's involvement. You can make disclosures for certain public safety or government purposes. Those are all those exceptions under 45 CFR 164.512, but just make sure that you have complied with the requirements for each of those. Okay? If you're not sure, contact your privacy officer. If your privacy officer is not sure, call me, because that's how I feed my children. For everything else, the general rule is you have to have a valid written authorization or request signed by the patient that complies with the relevant regulatory requirements. Those are the rules for use and disclosure. Let's talk about parents and personal representatives. Who is a personal representative under HIPAA? Well, generally, HIPAA says you treat the personal representative as if they were the individual. That means if you can disclose it to the individual, you can disclose it to the personal representative. Not only that, but the personal representative has the right to exercise the patient's rights. So they have a right to access that information. They have a right to amend the information. The personal representative does. So then the question is, well, who's a personal representative under HIPAA? A personal representative is the person who, under applicable state law, has the authority to make healthcare decisions for the person, right? If they've got the authority to make healthcare decisions, they've also got the authority to control their health information. So under Idaho law, or under your particular state law, who has the authority to make healthcare decisions? Under Idaho, we have a statute, Idaho Code 39-4504, that sets forth a hierarchy of who can make healthcare decisions. These are the personal representatives for purposes of HIPAA. You start at the top and you go to the bottom. People up at the top have more authority than people up at the bottom. So you start at the top and you work down. In Idaho, personal representatives would be, if there's a court-appointed guardian, they would be at the top. If there's no court-appointed guardian, is there an agent with a durable power of attorney that's been triggered? If no, if they're a spouse. If no spouse, then you'd look to the adult child. If there's no adult child, then you'd look to the parent. If there's no parent, then you would look for a delegation of parental authority, which normally never exists, so you'd look for another appropriate relative. If there's no other appropriate relative, then it's any other responsible person who represents themselves as responsible for the patient's health care, like the teacher, babysitter, nurse, something like that. So you can go ahead and disclose the information to that personal representative. Okay? What about divorced parents? I get this question a lot. Well, in Idaho, we actually have a statute that says you can't refuse to disclose information to the non-custodial parent. Just because they don't have custody does not mean they stop being the parent, despite what some moms may say about deadbeat husbands, okay, or ex-husbands. Generally, both parents have the right to access that information. At least in Idaho, we have the statute. The non-custodial parent is entitled to access the information. If the custodial parent wants you to delete certain address information, you can, but other than that, you get the situation, mom comes in and says, I don't want you disclosing this stuff to my ex-husband because he's a louse. Your response is, under Idaho Code 32-717A, I've got an obligation to do it. If you don't like it, go get the court order that tells me I can't, but other than that, I've got an obligation to disclose it, and you don't have to get in the middle. Question? Okay, so the question is, what do you do about deceased persons? Okay, and the sister wants to see the records. And there is no release of information. Okay, she's the next of kin. So what do you do in the situation of deceased persons? Well, as I mentioned a little bit earlier, remember, it used to be that under HIPAA, you would disclose the information to the personal representative. The personal representative was the person with the authority to make decisions for the patient or the patient's estate. So you'd have to go out and find whether or not this person was the personal representative under applicable state law. But remember, under the omnibus rule, they changed it, and now you can go ahead and make disclosures to family members or others involved in the patient's health care, and they extended that to persons, that applies also to deceased persons. So now you don't have to necessarily, you can disclose information even if the person is not the personal representative, as long as they were a family member or other person who was involved in the patient's health care before their death, and the patient didn't otherwise indicate before they're dead, or I guess after their death, which would be really cool, that they don't want that information disclosed to that person. Yes? Wyoming has a bunch of squirrely statutes when it comes to the rules. And that's why I said at the very beginning, you've got to look at your state laws. All right, there are certain circumstances where you can decline to treat a person as the personal representative. If, for example, the minor has authority to consent to their own health care, well, then they don't need the parental consent. That other person can't consent to their health care because the minor has their own authority to consent to their health care. So in that situation, they would not be the personal representative. If the parent agrees that the provider may have a confidential relationship, so parent brings in a child, They know that the child's not going to disclose information about their sexual promiscuity or whatever to the healthcare provider unless they know that they're going to keep it confidential. Mom may agree, okay, go ahead and keep it confidential. In that situation, then you can agree to keep it confidential. You don't have to treat the mom as the personal representative. Or if the provider determines that treating the personal representative as the patient is not in the patient's best interest, maybe you think that the father is the abuser. In that situation, you decide that I'm not going to treat them as the personal representative because it's not in the patient's best interest. But those are pretty limited circumstances. Yes, ma'am.
So in a situation where a minor has corresponding right of privacy along with the care, and, for example, parents come in and request for records, and there's birth control on the record to a minor child, do we need to withhold that information, or does the child need to assert that right of privacy?
So the question is, what do you do in a situation where the minor can consent to their own health care and the parent wants the information? What do you do in those situations? That is a perfect segue into the next slide, which this summarizes the issues dealing with family members and personal representatives. So general rule is you got to have an exception before you can disclose the information, right? So what are the exceptions? Well, if they're the personal representative, you can make the disclosure, but that's only if they have the authority to make health care decisions. In that situation where the minor can consent to their own health care, then the parent would not be the personal representative, at least for that particular part of the information, right? So then you have to have another exception. Well, you can make, is the disclosure for purposes of treatment, payment, or healthcare operations? It may be. In fact, it may be a situation where the parent's the one paying for the care, and there's an OCR FAQ that specifically says, hey, if you've got a situation where the minor comes in, gets care, you can disclose information to the parent necessary for you to obtain payment, but just don't disclose more than is minimally necessary. Okay? Third one, you can make the disclosure to family members or others involved in the patient's health care or payment for their health care, so long as the patient didn't object, you otherwise think it's reasonable under the circumstances, and you don't disclose more than that person's involvement. Or maybe if there's another exception that applies. Maybe you need to make the disclosure because it's necessary to avert a serious threat of harm. You think that the child's going to run away with somebody or take drugs or something like that, and maybe you need to make the disclosure in order to protect the patient. Okay? The government has issued a very helpful guidance on communicating with a patient's family, friends, or others involved in their health care. If you're dealing with the situations with parents or family members, you may want to call that up and take a look at that. Yeah, Teresa. Okay. So the question is, in Idaho, where the non-custodial parent is entitled to access the information, what happens in that situation if you think that the non-custodial parent is abusive, or any parent is abusive in that situation? Given the Idaho law, can you still disclose the information, or can you still withhold the information? Yeah, you can, because I think that you can, because HIPAA would be more restrictive in that particular situation. So I think that you're probably justified. I would take the position that HIPAA would preempt it. All right, let's talk about business associates. This is a growing issue because, as I mentioned, the government has really been focusing on business associate situations. Not only fining entities, we had our first case for fining somebody just simply because they didn't have a business associate, but also last year there were a couple of cases where the business associate went out and screwed up. They lost the protected health information, and guess what? The covered entity was the one that got hit for it. And they got hit for big bucks on those situations. So it's really important that you have business associate agreements in place. So what's the rule? The rule says that you may disclose protected health information to business associates if you have a valid business associate agreement. Entities, well, who is a business associate then? Basically, you can go through the definition up here, but basically business associates are those entities whom you are paying or contracting with, or whom you want to do something with your protected health information. You are engaging them to do something with your information, to create, receive, maintain, or store your protected health information, okay? It can include other covered entities acting as business associates. So you may be a hospital, but in your capacity as a hospital, maybe you also contract to provide billing services for another entity. If so, then you can also be a business associate as well as a covered entity. It also applies to subcontractors of business associates. So that business associates go ahead going to provide you with services, but they're going to contract out to other entities to help them, that you've got to have a business associate agreement with them. Okay? So who are not business associates? Well, members of your own workforce, your own employees, the people you have control over, your volunteers, those people, if you've got control over them, then they are not business associates. They're just part of you. So you don't need a business associate agreement with each of your employees. Now, you may want to have, well, you should have a confidentiality agreement with them, but you're not required to have a business associate agreement. Entities who do not handle PHI as part of their job duties, even if they may periodically see it, but if they're not paid to do something with it, then they're not your business associate. So, you know, like your janitor, that's the classic example. Your janitor's in there cleaning up. There's a good chance they're going to see PHI, but do you want them looking at the PHI? Hey, come in here, sweep up. Would you mind just checking the records, make sure I did that stuff all right? No, they're not your business associate. Entities that receive protected health information to perform functions on their own behalf, they're not your business associate. When you submit that claim to Blue Cross, is Blue Cross doing that for you? No, Blue Cross is not here for you, okay? Blue Cross is doing that as part of their own functions. They are not your business associate. Other healthcare providers, while providing treatment, you can go ahead and send your information off to that lab or off to that other healthcare provider. They're not there providing services for you. They're healthcare providers. They're doing it on their own behalf. Other healthcare providers are not business associates for purposes of providing their own treatment. Data transmission companies that do not routinely access the protected health information. So your internet provider, your phone company for the texting, of course, that raises the question about whether or not you should be texting protected health information, which we'll talk about later. But if all they are, if they're just a conduit for sending off that information and they don't regularly access it, then they're not your business associate. In contrast, data storage companies, they are your business associate because they are maintaining your information. They're not, it's not just a conduit to transit. It's not transitory in nature if they're maintaining it. In that situation, even if they don't have access to it, your storage entity, they are your business associate. Okay. In the materials we provided to you, I've given you a business associate decision tree, which is really boring, so I'm not going to go through it. The government has issued some really helpful guidance on cloud computing and cloud storage vendors and things like that. So if you are using any cloud storage service providers to handle your protected health information, the bottom line is you need to get a business associate agreement with that cloud service vendor. Again, it doesn't matter whether they don't access the information, whether the information's encrypted, and they don't have the key. It doesn't matter. If they've got the information, the government's taken the position, the OCR's taken the position that you've got to have a business associate agreement with those entities. All right, let's talk about then business associate contracts. The way that this works is if you're a covered entity and you are sharing protected health information with your business associate, you've got to have this business associate agreement in place. If that business associate agreement is sharing protected health information with the subcontractor, that business associate has to make sure they've got a business associate agreement in place with that subcontractor. The business associate, the covered entity needs to make sure they've got the business associate agreement in place with the business associate, and the business associate also has an interest in doing that, because even if you don't have the business associate agreement in place, that business associate is still subject to HIPAA violations, right? And one of the HIPAA rules requires them to have a business associate agreement in place. So even if you don't have a business associate agreement in place, that business associate is still liable for HIPAA violations. When it comes to getting the business associate agreement between the business associate and the subcontractor, OCR said, hey, that's the business associate's responsibility. You, as the covered entity, don't have to check on that. You have a business associate agreement. One of the terms of your business associate agreement says that, hey, if you're going to go out and use a subcontractor, you've got to have that agreement in place. It's not your job as the covered entity to make sure they do that, as long as you've got those terms in your business associate agreement. Be careful, because this agreement between the business associate and the subcontractor, it can't allow the subcontractor to do anything that the business associate can't do under his business associate agreement. So the terms of the covered entity's business associate agreement also have to appear in the subcontractor business associate agreement, okay? So if there are any specific limitations that that covered entity has put on the use or disclosure of that information, it has to trickle down to the subcontractor. That's kind of a trap that's out there. Now, the government doesn't seem to be focusing too much on that because it's really a hassle to try to implement that. But just realize that that's the way the law works, that it can't allow that the subcontractor can't do anything the business associate can't do. And the business associate can't do anything that the covered entity couldn't do with the protected health information. The business associate agreement has to contain certain required terms. Again, that's really boring stuff, so I'm not going to go through it. Just make sure in the materials that we provided to you, take a look at that. I provided you with a checklist of what should be in your business associate agreement. You need to make sure all of those terms are in there. The government has published sample business associate contract language. It's not intended that you can just print this off and use it. It's just supposed to be sample language. But it kind of is the standard for most of your business associate agreements. But there are additional terms that you're probably going to want to put in there. There are terms that are more beneficial if you are the covered entity. There are other terms that you want to address if you're a business associate. Let's talk briefly about some of those. If you are a covered entity, you may want to add the following terms to your standard business associate agreement or make sure that they're in there. You may want to require that the business associate report if there are breaches within a certain number of days. Because remember, way back at the beginning, if you correct the situation within 30 days, you can avoid HIPAA penalties, right? So you want to make sure that that business associate reports to you as soon as possible so that you can take appropriate action. So you may want to put in there that you require your business associate to report it within 2 days, 3 days, 5 business days, something like that, to make sure that you get that information. You may want to require the business associate to implement appropriate policies or encrypt data. You may want to require the business associate to carry data breach insurance so that if there is a breach, that you've got a resource that you can go to in order to collect if you're held liable for what that business associate does. You may want to require that the business associate has the responsibility to notify individuals if there is a breach so that you don't have to bear that cost, or alternatively, that they reimburse you for the cost that you have to have because of their breach. You want to make sure that the business associate defends and indemnifies you for any losses, claims, or other damages that you may suffer. Confirm that the business associate is an independent contractor, not an agent. We'll talk about that in just a minute, but generally you're not liable for what the business associate does as long as they are not your agent. So you want to make sure that they're an independent contractor, not an agent. Make sure that that document says you're an independent contractor. Also make sure that your business associate agreement does not impose so many restrictions on that business associate that you're essentially becoming their master, right? That you're controlling everything that you do, because if you do, you may be determined to be, that business associate may be an agent of yours. Make sure that the business associate assumes liability for subcontractors so that they're responsible. If the subcontractor messes up, that the business associate's on the hook for it. Allow termination of the underlying agreement. If they're messing up with your business associate, they're not complying with the business associate terms, then allow for yourself to be able to terminate the underlying services agreement. It's fairly common to make sure that they have your consent before they operate outside the United States, because you may have that nefarious, those Russian hackers who are out there, doing this stuff. If the information is maintained off-site, then that other entity may claim, hey, we don't comply with HIPAA. We don't care about what HIPAA says, right? You may want to reserve to yourself the right to inspect and audit, although there's pros and cons with that. Make sure that they're going to cooperate in any HIPAA investigations or actions and that they're not going to charge you for it. And you may want to confirm that the business associate was not excluded from participating in Medicare or Medicaid to make sure that you don't get hit up with any fines or penalties under the OIG exclusion list. Okay. So for those situations, if you're a covered entity, you probably want to address or consider addressing those in your business associate agreement terms. If you're a business associate and you're dealing with subcontractors, you want to make sure that you're addressing those types of things. On the other hand, if you're a business associate, you generally don't want those things in there, right? Because it's just going to increase your potential liability. So if you're a business associate executing a business associate agreement, you want to make sure the following terms maybe appear in your agreement. You want to make sure that you condition your obligations on your status as a business associate. There's a lot of times that covered entities, just to be safe, we're going to have everybody sign a business associate agreement, even if you're not a business associate. If you're a business associate, you don't want to assume those liabilities, right? You don't want to if you're really not subject to HIPAA, you don't want to assume those responsibilities. So you may want to confirm in your business associate agreement that, hey, we agree to these things only if and to the extent that we are actually a business associate. You may want to state that the covered entity is only going to disclose protected health information to you if it's necessary, because you don't want the protected health information if it's not necessary, because that just creates your liability. You may want to state that the covered entity will not request any action that violates HIPAA, because remember, HIPAA, under the business associate agreement, you can't do anything as a business associate the covered entity couldn't do or that would violate HIPAA. So you don't want that covered entity asking you to do things that would violate HIPAA. You may want to have the covered entity confirm that they've obtained the necessary authorizations that would allow third-party disclosures, if you're going to make those disclosures on behalf of them, that the covered entity will not agree to additional restrictions on the protected health information. When you're going into this business associate agreement, if you're a business associate, you're assuming that they're going to comply with HIPAA, right? But that covered entity, remember we said that the covered entity could agree to additional restrictions, and if they agree to these additional restrictions, then they've got to comply with it. Not only they would have to comply with it, but the business associate would. So as a business associate, you may want to put in there that, hey, covered entity, you're not going to agree to these additional restrictions, because if you do, it's going to increase our cost and our burden. And if you are going to agree to those, you can't do it without our permission, or if you are going to agree to those, that we have the right to terminate or to charge you for the additional costs. So those are some things that you may want to consider. You may want to limit your liability or any damages, probably try to exclude any obligation that you carry insurance, or maybe cap your liability on the available insurance, things like that. Okay, when it comes down to negotiating the business associate agreement, it comes down to bargaining power, right? You are the covered entity, you send your business associate agreement, especially if your business associate is a big entity like McKesson or something else, you send them your business associate agreement. What do? They send you back their business associate agreement that protects them. So it comes to a point of negotiating which one you go with. As I mentioned, the general rule is that a covered entity is not liable for the acts of its business associate unless two situations, okay? The first is if that business associate is acting as your agent, meaning that you have exerted such control over what they're doing, you're telling them every little single thing that they're doing, well, the government says, okay, well, if you're exercising that control, you ought to be liable for what they do. So be careful about exercising too much control over your business associates, because that may make you vicariously liable. Although it's not in the regulations, as I mentioned, in some of the recent cases where there have been significant violations by the business associate, the government has also come back there and held the covered entity liable for what they did. In one case, it was $1.55 million. Why? Because the covered entity or the business associate lost a laptop and there was no business associate agreement in place. And so they kind of made the covered entity vicariously liable for what that business associate did. So make sure you've got the business associate agreement in place. Okay, the other way that you can be liable is if you knew that the business associate was screwing up and you didn't do anything about it. So if you know that the business associate's screwing up, you got to do something about it. Either take steps to ensure that they correct the situation, or you got to terminate the agreement. If you don't, then you can be liable for your own violation. Because of all the concerns about business associates, a lot of people have said, well, we're going to impose requirements that we have to come in there and supervise what our business associate's going to do. We're going to require, we're going to come in there and do audits, or we feel obligated to come in there and do these audits. I've had situations where HIPAA consultants have come in and told the covered entities, no, you've got to go in and you've got to audit your business associates. No, that's not the case. The government has specifically said HIPAA does not require the covered entity to actively monitor the actions of its business associates. Rather, the rule only requires that where a covered entity knows of a pattern or activity or practice that constitutes a material breach, that they take appropriate steps. How did the government, they said, when this whole issue came up, it was proposed that, well, let's require the covered entities to monitor what the business associates do. And the government said, no, that's too burdensome. We're going to solve that by requiring the covered entities to put in place business associate agreements that require the covered entities or the business associates to comply. But once you've done that, you've satisfied your obligation unless you know that they're out there screwing up. So be careful about undertaking those obligations to monitor and to audit. You can if you want, but it's problematic because, one, it's expensive and you may not have the time, and two, if you undertake that obligation and do it negligently, then the government may hold you liable, either because they're acting as your agent or some other for some other theory. So be careful before you assume all of those obligations. So business associate summary. If you're a covered entity, when in doubt about whether or not you use the business associate agreement, use the business associate agreement. If you're a business associate, don't assume business associate liability if you can avoid it, okay? Make sure that both parties review the terms of the business associate agreement carefully. Beware terms that aren't required by HIPAA. They're out there, and remember, the covered entity wants to put as much responsibility on the business associate as they can. Conversely, the business associate doesn't want to. It wants to shift that responsibility, so make sure you look at the terms. Remember that if you're a business associate, you've got to comply with the business associate agreement terms. So now you not only got to be concerned with HIPAA, you also got to be concerned with the business associate agreement terms. Because if you violate the business associate agreement terms, even if that violation was not a violation of HIPAA, HIPAA didn't require that particular term, under the rules, if you violate the business associate, you're also violating HIPAA. So you got to comply with the more restrictive standards, okay? So make sure you're aware of that. You comply with the business associate agreement terms. All right, let's talk about making the disclosure. Remember, under the HIPAA, we've talked about all of these rules for when you may disclose. The general rule under HIPAA is, hey, under these exceptions, it only allows you to make the disclosure. It doesn't require you to make the disclosure. There are limitations to that, though. The only time that HIPAA requires you to make the disclosure is HIPAA requires you to respond to the patient's request to access their information or to disclose their information to a third party. Or if the government comes in, HHS comes in, then you've got to make the disclosures. Obviously, if there's another law that requires you to make the disclosure, you better make the disclosure consistent with that law. But that's not a HIPAA issue. That's an issue under that other law. The question was raised by Melissa, who is one of my favorite people in the entire world, about verification issues. Generally, you have an obligation before you can disclose protected health information. You've got to verify that the person to whom you are disclosing the information is who they say they are and that they are entitled to access the information. What do you need to do? You've got to take reasonable steps to verify who they are. So if they're calling on the phone, maybe you ask for the patient's birth date or something like that, or the social security number, some kind of information. If they are accessing through electronic portals, well, your portal system should have authentication anyway, right? And so they should be able to access and it shouldn't really be an issue. If you're getting the letter from the attorney who says, hey, here's my patient's signature, we want to go ahead and produce that, then you need to take appropriate steps to verify. What are appropriate steps in those situations? Who knows? The government just says to be reasonable. I think if you're getting that representation for the patient's signature and you have no reason really to doubt it, I'm not sure that the government would really care too much about it. I don't think you probably need to go beyond just looking at it. It looks reasonable to me and go ahead and produce it. I doubt that it's ever going to result in any fines or penalties. Make sure when you are asking for verification, though, that you don't put in place unreasonable barriers to access. For example, yeah, we're only going to provide that information but only if you come in person and show me your photo ID. In those situations, the government says, no, that's an unreasonable barrier to access, and that would be a violation of HIPAA. So you've got to kind of play the middle here, right? You got to ask for appropriate verification, but you can't take so many steps that it becomes a burden on the patient. HIPAA says, under the general, so the question is, can you require a social security number in order to get to the portal? Yeah, I'm not aware of anything that would prevent you from doing that. You need to have appropriate authentication issues. And I think that that would be reasonable. Most people know what their social security number is or can find it or should know. Sometimes they may not want to offer it, but that's more of an issue for probably, well, I suppose it could be viewed as an unreasonable barrier because under HIPAA, you just have an obligation to verify. And there's nothing under HIPAA that allows you necessarily to get the social security number. So if you're refusing to provide that because they won't give you the social security number, then you may have an obligation to ask for some other means of verification. All right, HIPAA says that even though you may disclose the information, you can't disclose more than is minimally necessary. So you got to comply with the minimum necessary standard. That minimum necessary standard does not apply to disclosures to the patient or disclosures to another provider for treatment or certain other circumstances. As part of that minimum necessary standard, this is a common violation out there. You supposedly have to go through and come up with these policies for enforcing the minimum necessary standard. Among other things, you've got to identify those persons in your organization who have access to certain information and what kind of access they can get, okay? So you have these minimum necessary access policies. So you would have this role-based access that all physicians can access this types of information. Schedulers can only access that information. You've got to establish those policies. Okay, let's talk about patient rights. Got 20 more minutes. We're almost done, guys. Hang with me. All right. The first right that the patient has is a right to receive the notice of privacy practice. Remember that notice. Think of the notice as kind of a contract between you and the patient. This is how we're going to use your information. Okay? HIPAA says you got to get this notice of privacy practices. If you're a direct treatment provider, meaning that you're not like a radiologist or pathologist who only work in the back room and never have contact with the patient, if you're a direct treatment provider, then you've got to provide that notice of privacy practices no later than your first date of treatment. If your first date of treatment is electronically, then you're supposed to set it up so that notice goes electronically. Direct treatment providers, you've also got to put that up on your website, and you've also got to put notice of privacy practices, post it in your organization, and give a copy of that notice of privacy practices to the patient no later than the first date of treatment. Simply having it available for the patient isn't enough. You're supposed to actually give it to them, but you know, patients never take it. If they do take it, they never read it, so they throw it on the floor. You just pick it up and put it back in the pile. Okay? You've got to make a good faith attempt to obtain the acknowledgement that, from the patient that they received a copy of that. Usually what I do is just on your registration form, I just have a box there that they initial where they say, I hereby acknowledge that I have received a copy of the notice of privacy practices on this or a prior occasion. The government has issued or prepared a model notice of privacy practices, and it really sucks. Don't use this one. If you're a healthcare provider, it's very pro-patient, okay? I really don't like it. In the materials that we provided to you, I've given you a checklist of what the notice of privacy practices has to have in it. I would probably limit it to what it has to have in it, okay? This is really important. Among other things, your notice of privacy practices has to specify the uses or disclosures that you can make of that protected health information, and it has to contain a statement that says something to the effect that for other uses or disclosures, we have to have your authorization. Okay? That means that if you don't list out those permissible exceptions, you're not supposed to be able to use them. So make sure that you go back and look at that notice of privacy practices, and it has all of those things that you think might come up in your organization, all of those exceptions under 45 CFR 164.512, including disclosures to family members, facility directory, all of those other things. Make sure that that has it. Go home, look at that notice of privacy practice. You didn't have anything more fun to do this weekend anyway. Check our checklist of the notice of privacy practices against your actual notice. Next right a patient has a right to request restrictions on the use or disclosure of protected health information for purposes of treatment, payment, or healthcare operations. You have a right to request it, but guess what? You don't have a right to agree, or you aren't obligated to agree. And my advice, again, don't agree to those restrictions. Okay? It's kind of like the parent-child rule. My daughter frequently exercises her right to come and ask me to use the car, and I exercise my right to tell her no. You can't. Okay? So you don't have to agree. Okay? If you are going to agree, you better comply with that. Make sure that you reserve your right to make appropriate disclosures. Okay? There is an exception to that if the patient has an encounter that's covered by insurance and they pay for everything themselves or have some other third party pay for everything themselves, and they tell you, don't disclose this episode of care to my insurer, then you've got to comply with that. Now, that is a real hassle. How in the world do you ever segregate that encounter information from the insurer? It's really a hassle. The good news is it only applies if the patient asks for that. So, you know, don't ask, don't tell. This is the situation. Never ask the patient if they want you to limit their disclosures in those situations, okay? Because if they don't, if you don't ask them, they're probably not going to ask you to, and then you don't have to worry about it. The government has issued a bunch of guidance on this. If you do get a request from the patient to limit your disclosures in those situations, then take a look at the guidance on that. It appears in the omnibus rule commentary. A patient has a right to request alternative communications by alternative means or to alternative locations. So a patient comes in and says, hey, I only want you to send my information in an unmarked envelope to my work address because I don't want my husband to see that I'm pregnant. You have to comply with reasonable requests. Okay? That includes communicating by email or text. The general rule is under the security rule, like Matt's going to talk to you about in a few minutes. General rule is you can't communicate by unsecured email or text, okay? Because it violates the security rule. There's an exception, though. That, remember, HIPAA says, hey, the patient can request alternative means of communication. That means that the patient says, hey, I don't care if it's unsecured. I want to communicate by email or text. If it's reasonable, then you have to comply with that. In the case of communicating with patients via unsecured email or text, the omnibus rule just says that's fine. Patient requests it, then you got to do it. Just make sure that they know that that communication is unsecure and it may be subject to access by third parties. As long as they know that, you've documented, then you're fine. You can go ahead and communicate with them. Note that that applies to communications with patients, not necessarily communications with other providers. So general rule is you can't communicate with other providers or others on your staff via unsecured email or text, or you can't send protected health information over the unsecured email or text. The right to access. The individual generally has a right to access their protected health information, but not all their information, only the information that's maintained in their designated record set, which is pretty much all their information. It's basically all their information that concerns their health care or payment for their health care. If it's maintained in the designated record set, they have a right to access it. Okay? And by the way, it doesn't apply just to the information you created. If you got information from another doctor and it's maintained in your designated record set, they can still access that too. Doesn't matter whether it came from another provider. The government's guidance specifically makes that clear. There are certain exceptions. The patient does not have a right to access information that's outside the designated record set, like your quality assurance, peer review, that type of stuff. Psychotherapy notes, information in anticipation of legal action, information provided under a promise of confidentiality, or information if access would cause substantial harm to a patient or other person. Under this last one, if you're not going to disclose it because you think it's not in the patient's best interest or that it would cause substantial harm to the patient or others, you can decline, but the patient has a right to have that reviewed by an independent practitioner. Generally, you've got to respond within 30 days to those requests. You can get a 30-day extension if, for example, you have to collect the information or recover the data from off-site. Now, I mentioned earlier, the government's issued this guidance on patients' right to access. It is a must-read for any of you dealing with protected health information. Quite frankly, the government took the rules and went a step further, sometimes 3 or 4 steps further than what the rules actually set forth. So you really need to get this and you need to understand it and apply this in dealing with patient information. In the interest of time, I'm not going to go through some of those things because you're going to promise I'll read it, right? Okay, all right. A couple of things, though, on reasonable cost-based fees. They have a lot of FAQs in that guidance concerning what you can and cannot cover. The bottom line is this: you can charge a reasonable cost-based fee to the individual to disclose information to the individual or personal representative, or if the individual requests the disclosure to a third party, you're limited to a reasonable cost-based fee. That means the labor for copying, requesting, transferring the email or the like, supplies for creating that, the postage and preparation of the summary if the patient agrees that you can do the summary. But you have to notify the patient in advance of those costs. In that guidance, they actually said that you ought to post your costs on your website. That's another example of where they kind of went beyond the rules. Okay? When they're talking about the reasonable cost-based fee, you can only charge the cost for the actual copy. Okay? The cost for getting the records to you to do the copying, you can't charge for that. The retrieval fee, reviewing the request, all of that stuff, you can't charge for that. It's only after you've collected all the information you can charge for the time that it takes to convert that into the, if they want an electronic copy, to convert it into that, to actually sit there at the copy machine and make the copies, you can do that. But the time getting those records together, you can't charge for any of that stuff. When it comes to electronic records, the government has said you're not required to. You can charge actual costs or average costs, but when it comes to electronic records, if you want to, you can charge a reasonable fee of $6.50 per request. That's not per record, that is per request. Okay? They specifically said in the guidance that if you're providing electronic records, you should not be charging a per page charge. They said that's inappropriate for electronic records. Those are the types of things you need to go back and look at those records. Okay, next one, a patient has a right to request an amendment of their health records. Note that this is a patient has a right to request the amendment, not necessarily have the amendment made. You can refuse the amendment if the records was not part of their designated record set, or they did not create the record unless the creator is no longer available. Patient comes to you, hey, change this record. Hey, Dr. Jones created that record. I'm not going to change the record. You don't have to change the record if Dr. Jones created it unless Dr. Jones is dead. If the record's not subject to access, then you don't have to change it, or if, most importantly, the record's accurate and complete. Yes, I'm not going to change that record because the record was accurate and complete. In those situations, you would have to notify the patient. The patient would have a right to have that request for the amendment attached to the record if you're denying it. If you're going to accept the record, then you've got to go ahead and have that record changed. You've got to get permission to notify others who may have relied on the record of the change. It's a real hassle. Bottom line is, fortunately, not many people request amendments. If they do request amendment, make sure that your privacy officer goes through the rules and understands what the requirements are. You generally have to respond to those requests for records within 60 days. Right to an accounting of disclosures. I think of all the HIPAA rules, this is probably the one that's the most frequently violated. Okay? HIPAA says that the individual has a right to request an accounting of all disclosures made for the prior 6 years with certain exceptions. The net effect of it is basically the only disclosures that you have to make are disclosures that were done in violation of the law, so they're HIPAA violations, or disclosures pursuant to 45 CFR 164.512. That's disclosures to like the police, those types of situations. You don't have to disclose, keep a record of disclosures for treatment, payment, and healthcare operations, or disclosures per the patient's authorization, or those types of things. If a patient comes in there and requests that, then you've got to respond to that request within 60 days. You can obtain a 30-day extension. That accounting has to include this information, including the date of the disclosure that you made, the name of the entity receiving the disclosure, the description of information disclosed, and describe the purpose of the disclosure. Even though, let's face it, how many times have you guys received a request for an accounting of disclosures? Almost never. So does that mean you don't have to track this? No, you're still supposed to track it. But nobody does it. But if you fail to do it, the government may come after you. So the bottom line is you're supposed to track this information, not only for you, but your business associates are supposed to track that too. Because if the patient comes in there and asks you for an accounting, they get accounting not only of what you did, but also what your business associate did. So make sure your business associate agreement states that they have to maintain that accounting. Yeah, questions? Yeah, the question, right. Okay. Yeah, it's a good comment. Usually when you get a request for an accounting, quote unquote, they're really trying to find out who accessed their information. And then the question is how you respond in those types of situations. And generally, just a blanket request for who accessed their information, they're generally not entitled to that. They're only getting an accounting of certain disclosures that you've made, and so you can refuse that. Now, with this caveat, that is under the HITECH Act. When they amended the HIPAA in 2010, came out with the HITECH Act. The HITECH Act says that if you maintain an electronic health record of patients, then you're supposed to have the capability, the functionality to track who did access the information, including disclosures or disclosures for treatment, payment, or healthcare operations. Now, we have not got the final rules on that yet. Even though they were due several years ago, we haven't got the final HHS rules on that. So the bottom line is, even though the statute says we're supposed to be able to do this, we haven't got the rules. From my perspective, I don't think you need to worry too much about this until we do get the rules. When you do get the rules, under the statute, it's got to provide, your EHR has got to have the functionality to track the kinds of things that you were talking about. If the patient comes in and wants a record of everybody who accessed their information, you've got to be able to generate that. The bottom line between now and the final rules is if you are contracting for EHR functionality, make sure that that functionality is going to cover these types of reports. All right. Let's talk briefly about administrative requirements. HIPAA requires you to designate certain officials, including your privacy officer and your security officer. Everybody's got to have one. Privacy officer and security officer has to be a designation in writing so the government knows who to go after if there's a violation. You've got to implement appropriate policies. You've got to train your workforce concerning the policies. That's really important because in the commentary, the government said, hey, if you have these policies in place, you train the employee, and the employee just went rogue, then that is not willful neglect on your part. So you can avoid HIPAA fines and penalties so long as you correct it within 30 days. So it's really important to have those policies and provide the training. You've got to implement reasonable safeguards. What are reasonable? Well, it depends upon the particular circumstances. This is important because the government has said an incidental disclosure is not a violation of the privacy rule. which means you don't have to report it on the breach reporting. So what is an incidental disclosure? It's a disclosure that happens just along the way, right? As long as you have reasonable safeguards. Patient walks down the hall, they may hear another patient's name, or they may see something up on a whiteboard. But as long as you had reasonable safeguards in place, then those are incidental disclosures and they're not breaches under HIPAA. You don't have to report those. You've got to respond to complaints and violations, including documenting appropriate sanctions against employees who violate. If you don't, then you can get hit up with HIPAA fines or penalties. All right, in my final 5 minutes, let's talk about breach reporting. Under HIPAA, you have an affirmative obligation. You've got to narc on yourself. If there's a breach of unsecured protected health information, it only applies if there's a breach of unsecured protected health information. So let's talk about what those are. First of all, what's unsecured protected health information? Well, essentially, unsecured protected health information is any information you got unless it's encrypted, according to standards that the government has set. Okay? If it's encrypted and you have a lost laptop, but the laptop's encrypted and that encryption satisfies the government standards, it's not a breach. You don't have to report it. On the other hand, if it is not encrypted, then it's presumed to be a breach. What is a breach? A breach is the acquisition, access, use, or disclosure of protected health information in violation of the privacy rules. It's presumed that unauthorized access is presumed to be a breach unless you can demonstrate that there's a low probability that the data has been compromised, whatever the heck that means, based on an assessment of these 4 risk factors, unless you can fit within an exception. The exceptions are basically those situations where somebody in your organization inadvertently accesses the information. They went in for John Smith's records and didn't realize there were 2 different John Smiths, right? As long as it was inadvertent and they don't disclose it further, that's not a breach. Similarly, if there's an improper disclosure, they go in and the physician comes out and says, hey, Nurse Jones, I want you to take care of patient Y, not realizing that it wasn't this Nurse Jones, but it was that Nurse Jones who was responsible for that patient. As long as there was an inadvertent disclosure, but as long as they don't further disclose it, then it's not a breach. The third exception is if you have reason to believe that the disclosure will not result in, that the person who received the information would not be able to retain the information, then that's not considered a breach. The example that they gave is you've got the physician that comes out giving discharge instructions, hands the information to the wrong person, but immediately realizes it and takes it back. Okay? The person didn't really have time to read it. In that situation, that's not considered a breach. For everything else, it's presumed to be a breach unless you can demonstrate that there's a low probability the data has been compromised based on these factors. The nature and extent of the information involved, including the types of identifiers. The second factor, what was the nature of the unauthorized person who used or disclosed the information, whether the information was actually acquired or reviewed, or to the extent to which the information, the use or disclosure has been mitigated. Based on the commentary that's come out, the government has indicated that these situations suggest that there's a lower probability that the data has been compromised. We haven't got a lot of guidance from the government on what is a reportable breach and not. They said they were going to give it to us, but hey, they make lots of promises. But they did say that these are situations that suggest there's a lower probability. So you have a situation where the fax is sent to the wrong physician, but the physician reports the fax and confirms he or she has destroyed it. In that situation, okay, low probability, you probably don't have to report it. If the disclosure was to a person who is otherwise required by HIPAA to maintain the confidentiality, in that situation, they said that's a lower probability. You may be justified in that situation not reporting it. Disclosure without identifiers or to an entity that lacks the ability to re-identify the information, or a stolen laptop's recovered and the analysis shows that the PHA was not accessed. Note, it's not just that the stolen laptop's recovered, but the analysis shows that the information was not accessed. But you still got to evaluate all the factors. On the other hand, they've said that the following situations likely do create a situation where it's going to be reportable. If the disclosure involves financial data, sensitive information, detailed information, or the disclosure involves a list of patient names, addresses, hospital IDs, et cetera, or if the information is mailed to a wrong individual who opened and read it and the person is not a covered entity or business associate in those situations, that's probably going to be reportable. So for whatever help that is, that kind of lets you gauge what type of stuff needs to be reported. The bottom line is this. The government has said that when it comes to breach reporting, when it comes to the breach reporting, if you may not have committed a violation, right, up until then. It may have been an innocent violation, no willful neglect. But if you learn that there was a breach, a reportable breach, and you fail to report it, that in and of itself may be a willful neglect. So you may get hit up with the HIPAA fines and the penalties. The net effect is it's safer in most situations, if it's a closed case, to go ahead and do the breach report and assume that it's going to be a reportable breach. Okay? Otherwise, you may get hit up with the HIPAA fines and penalties. Kim? So it's a situation where the government payer loses the information. They send it and it gets lost. Well, the government payers probably aren't covered by HIPAA. May or may not be covered by HIPAA depending on the situation. If they're a health plan, then they may be covered by HIPAA. But it's their problem. It's not your problem. They're the ones who lost it. In general, if it's information from your office and it's lost, even if you're not responsible for it, the breach notification rule is interesting. I've had to deal with this quite a few times. It doesn't turn on whose fault it is. It just says if you become aware of the breach, then you've got to report it. And so my rule of thumb is, look, if it involves our information or any of our people, then we're going to report it, even if we weren't at fault. Okay? In that situation, though, where it comes in from a third party, I don't think that they would necessarily be reportable on yours. If there's a question about that, what you may want to do is contact the payer saying, hey, we understand that there's this information is lost. We assume that you're making the breach, let us know, or the breach report, let us know if it's not, if you're not. Okay. All right. If there is a breach of unsecured protected health information, then you have an obligation to notify the individual. You've also got to notify HHS. Every time you notify the individual, you're going to have to notify HHS. If the breach involves more than 500 persons in the state, you also got to notify local media. Note that that's 500 persons in that particular state. So if you have a breach and 400 people are in Idaho and 100 people are in, or 500 people or 400 people are in Oregon, you don't need to notify local media because you haven't got 500 persons in a particular state. If you are a business associate and you become aware of the breach, you've got to notify the covered entity so the covered entity can make the breach. That breach notification has to be done no later than 60 days, but that's a little bit misleading because the government says, hey, that's the absolute outside time limit. If you can complete the report and make the breach, do the report within 2 weeks, you got to do it within 2 weeks. And remember, you're going to want to do it as soon as possible anyway, right? Probably because you're going to want to show that you corrected the situation within 30 days to avoid HIPAA fines and penalties. That notice has to contain certain required elements. It has to be sent by first-class mail as the general rule. If you don't know where the patient is, then you've got to use substantive forms to give that notice. When it comes to doing the notice to HHS, you go ahead and you log on to the government's website and you do that notice electronically. If the breach involves less than 500 persons, you can wait until March 1st of the next year, depending on 60 days after the end of the calendar year, so I guess it depends on whether it's leap year. Okay. My theory is if it's not a big substantial breach, wait until next year to do it, and then it'll get lost with the hundreds of thousands of other breach reports that are all going in on the same day. Okay. If it's a significant one, then you may want to do it sooner if you think the patient's going to complain just to show that you acted appropriately. If the breach involves 500 or more persons, then you've got to go ahead and do the report immediately at the time that you give the notice to the individual. You do that report by going to that website, and it'll walk you through the steps. If the breach involves more than 500 persons, your name is added to the wall of shame for those people who have had breaches involving more than 500 persons. Real quickly on ransomware, something that's on all of our minds given the recent events with the WannaCry situation. Bottom line here is I think that Matt's going to go through ransomware in more detail, but just real quickly, the government issued a guidance on the OCR from the OCR which says that hey, ransomware is presumably a reportable breach. I had taken the position that ransomware was not a breach because there was no access to the protected health information. It just encrypted it, right? But they didn't really access it. OCR disagreed with me. So go with the OCR. The OCR says that it's presumptively a reportable breach unless you can go in there and do the analysis and conclude that there's a low probability that the data has been compromised. Remember that when it comes to the breach notification that you've got the HIPAA obligations, you also have state breach notification laws. I think almost all states have these breach notification laws that are much broader than HIPAA. The state breach notification laws generally apply if there is an electronic breach of computerized data that contains Social Security numbers or other sensitive information. There's criteria that has to be satisfied. It's not limited to just patient information. It could be your employee information. It could be your customer information. Any of that stuff, it may trigger these state breach notification laws. Just make sure that you're aware of that. All right, in conclusion, real quickly, I know I'm over my time, but I'm going to go through these just really quickly. Here's my HIPAA top 10 list of what you need to do to make sure that you're not going to act with willful neglect so that you can avoid HIPAA fines and penalties. First, make sure that you've assigned and document your HIPAA responsibility to your privacy officer and security officer. 2, ensure they really know what they're doing. 3, review the security rule compliance. Remember, that's the big ticket item, right? Security rule compliance, that's where your exposure is these days. Make sure you're complying with security rule. That's why Matt is more important than I today. That means you need to conduct and document security risk assessment. That is commonly overlooked, but it is frequently cited. So make sure you're talking about doing the risk assessment. Matt's going to talk about that. Beware your electronic devices. Make sure they're encrypted. If they're not and you lose them, it's presumptively you've got to report it. If you don't report it, the government would, and they find out about it, they'll come after you for those situations. Ensure you have required policies for the privacy rule, security rule, and the breach notification rule. Develop and use compliant forms like your authorization, privacy notice, etc. Execute your business associate agreements with business associates. Ensure that your business associates are independent contractors because you don't want to be vicariously liable for what they're doing. Follow up if you think that they're screwing up with your information. If you do, then you can avoid HIPAA liability for what they do. Train your members of your workforce and document the training. Use appropriate safeguards like confidentiality agreements with your workforce members, reasonable administrative, technical, and physical safeguards. If there is a breach, respond immediately. Why? Because if you correct it within 30 days, then you may be able to avoid HIPAA penalties. Remember, mitigating the risk is one of the factors on whether or not you even have to report the breach to the OCR. So you may, if you can act immediately, you may be able to avoid any breach report. You want to respond immediately. You want to teach these people, your people, you don't sweep this stuff under the rug. That's not good. You want to know as soon as possible so that you can take appropriate action. So immediately take appropriate steps to mitigate, whether that's calling the person who got it to tell them to shred up the information, make sure that they don't disclose it to anybody else, retrieve the information, or ensure that it's completely destroyed and won't be further disclosed. Obtain assurances from whoever got that information improperly that no, they won't access the information or use the information further. You may send a follow-up letter to them telling them that, by the way, thanks for letting us know. By the way, if you do use this information improperly, you can get hit up with criminal fines. You can go to jail for this type of stuff. That usually gets their attention. Investigate facts to determine if there was a reportable breach. Sometimes there wasn't because it was only an incidental disclosure. Sanction workforce members as appropriate, implement appropriate corrective action, and document all of the foregoing. If you do all that and you determine there's a reportable breach, make sure that you do the breach report in a timely and appropriate manner. And if you do that, you can avoid the HIPAA penalties. As far as resources, the government has a very, very helpful website. I hesitate to tell you about it because I become superfluous if everybody uses this. But there it is. It's got a bunch of resources also on our website because I have no outside life and I do a lot with HIPAA stuff. I've got a lot of resources on my website. You can go in there and access those. And the cost is free. And you get what you pay for. So there you go. All right. That is it. I apologize for going 8 minutes over. We have a break. How about if we take, 10-minute break? 10-minute break. We'll be back here in at 10:35. So I think in that situation, if you have any questions, what you need to do is have any kind of confidentiality agreement that you're able to access, but that's already used. I think they're probably
dive into the slides with some hot topics. Kim left off, I'd like to start right back where he left off with the ransomware notice from the OCR. And if you've had a chance to read that, you'll understand how they've interpreted what we do when we've been victimized by ransomware, and it encrypts PHI or ePHI. So, brief introduction. My name is Matt Sorensen. I work for Holland & Hart. I'm in our Salt Lake City office. And I'll tell you, it's tempting to want to move up to Boise so I could work with Kim full-time, just get an office right down from him. He's fantastic. He's a hard act to follow, so I'm going to do my best. He showed you a website where he has created a lot of free content, checklists, and he distills a lot of the regulatory language down into practical tools. So he has a toolkit out there if you want to take a look at that. So ransomware is considered a security incident under the security rule. And whether or not it's a reportable breach, fact-specific determination based on what and how the ransomware came in and what it encrypted. The tricky thing with the ransomware, and I'm bringing this up right off the bat because we all have this worldwide ransomware attack kind of fresh in our minds off the last news cycle from the last week. When ransomware comes in and encrypts PHI, the OCR is interpreting that as the bad guys having access to the PHI. Now, security is all about confidentiality, integrity, and availability. And so it's the availability of the data that is at issue, really, with ransomware. Not so much confidentiality, because there's no evidence that ransomware takes that data, reads it, or exposes it to outside eyes. So under the traditional definition of security, we have an availability incident when we have ransomware. And so we don't have to report the breach if we can use that risk analysis that Kim talked about and determine that there was a low likelihood of compromise or low likelihood of data exposure. So I just want to caution you a little bit to be careful there, because on one hand, the OCR in their guidance says that a ransomware attack and infection is a security incident, and if it encrypts PHI, is a reportable breach. And so I don't see a really clear path to using the HIPAA breach risk assessment that was introduced in the omnibus rule to back out of that scenario, because they've said when that PHI is encrypted, it's an impermissible use. There's been access. So I have a slide later about WannaCry. This is the, and if folks on the webinar, if you can't hear me very well, send a message in over your interface and I'll speak up. I have a slide later. We'll talk about some of the mechanics of WannaCry and its origin and why it was so successful. Another news headline you may have seen in recent weeks, is there's a hacking collective or a hacking group called the Dark Overlord. Any of you heard of the Dark Overlord? I mean, this is almost comic book-like. It's these hacker groups and their names. It's like Darth Vader's coming to get us now, Dark Overlord. And I'm not trying to make light of it. It's a very serious threat. This group, known as the Dark Overlord, has been releasing health records, stolen health records from hacking activities, and been releasing them into the dark web, and causing a lot of pain and suffering for covered entities. The dark web is the internet. Pieces of the internet or parts of the internet that Google and other search engines don't index. And so when you go and make searches in a search engine, you're not going to receive hits and results on websites that are considered dark web. Dark web is where a lot of black market data trafficking in personal health records, social security numbers, carding forums you may have heard of, where stolen credit card, payment card information is bought and sold. And there's a healthy underground economy in trafficking stolen data. We have Dark Overlord has been releasing hundreds of thousands of stolen health records into these forums for sale. And I wanted to talk a little bit about what's the value of a health record? Why are we under such intense scrutiny? I mean, I'm getting an indicator. I need to maybe talk louder. I've got the mic about as close to my mouth as I can get it. So we come into these dark web forums and we can buy health records. Who do you think is buying personal health records, and for what purpose? It's not clear. There's not a lot of research that's gone into this, but I wanted to draw a little bit of a parallel with America's opioid crisis and prescription fraud. And so if an addict can get a hold of a personal health record, a name, a birthday, and maybe an insurance policy number, billing code, and go in and forge prescriptions, okay? I mean, I'm just drawing parallels in some of the news reports I've seen in the last year. We've seen in some states in the United States where over a year, there was a study done of how many opioid prescriptions were written in that state, and it amounted to 9 pills for every human being in that state in the course of a year, I think. Don't quote me on that. But it was an outlandish number, and you're left thinking, well, there's no way that every human being in that state consumed or needed 9 opioid painkillers in a year. So we have demand. We have obstacles in procuring and getting these prescription painkillers, and so who's going to supply them, and how will they be supplied? And I think we have a lot of healthcare record theft that's helped fueling some of that prescription abuse. So today, I got an email with a report from the Idaho Business Review, and the article title is a report on cyber attacks targeting healthcare industry, that 1/3 of the cyber attacks are targeting healthcare. This was a study done by a law firm called Baker Hostetler, and they surveyed 450 of their clients who they served in 2016 for data breach response. 450 healthcare clients who were hacked or had some other kind of impermissible disclosure. And got some interesting statistics. So healthcare accounted, they surveyed 450 clients in general across all industries. 450 total, 38%, and this is the highest percentage of their client base, were healthcare. So of all their clients who got hacked, the highest percentage was in healthcare. Number 2 was in finance and insurance. Number 3 was education. We've seen retail in the last 5-6 years, especially targeted for payment card theft. And when criminals can steal a payment card number and an expiration date, they can sell that, and someone else can use it to make purchases online. Those records in the dark web, in the black markets, payment card records, they've been going for $1 each or less. And so the value of stolen credit card and payment card data has gone down significantly, while the value of a healthcare record has gone up. And these healthcare records can sell for $20, $40, $50 each, depending on the quality and how new they are. This article goes on to say, I mentioned a few things that I think are very important for us as healthcare professionals working to secure health information. Verizon has a very popular report that they come out with every year called the Verizon Data Breach Investigations Report. And their 2016 report, I believe they've come out now with their 2017 report. And 80%, let me get this right, 80% of successful breaches were accomplished through stolen passwords or stolen credentials. Just want to make that right. So this just popped into my inbox today as I was sitting back there, so I want to share it with you. So we're just reading the newspaper together, so pardon my lack of slides. Okay, so I'm gonna quote Brian Whitlock, president of the Idaho Hospital Association. Health files go for a lot of money on the black market. It's been really eye-opening to me, and we are working with other hospitals and associations to build up protection. So Idaho Hospital Association. 6 times every second, this is the president again, quoting him, 6 times every second, the Idaho Hospital Association gets a hack attempt on our data. 8 out of 10 times it is Russia this year, but it has been China and Ukraine in the past. 6 times every second, and really what that means is there are a lot of hackers out there with automated tools running, looking and sweeping the internet for vulnerable systems. And so it's not like there are millions of people sitting at keyboards trying to hack into you right now, but there are tools that run and scan nonstop, and that accounts for 6 times every second. Okay. It took businesses an average of 61 days after an attack to notice their information had been compromised. 61 days. And so in the Verizon breach report, you'll see some statistics about how fast it takes a criminal to compromise your systems and how long it takes you to find out about it. So the compromises will occur in seconds and minutes, mostly seconds and minutes. A few of them will be more complex and take longer. But the time to discover is often weeks and months. And so that gives the attackers quite a bit of time once they've gotten in to search and look around and create different types of attacks to get into your different systems. All right. I want to get down to this password. You know, the hardest thing is training employees to not click the links in the phishing emails. So the #1 weakest link in your chain, in your cybersecurity program, is people. And not only people that click links and are subject to social engineering, but people that design and implement and configure the health IT systems, both in your covered entities, in your hospitals and clinics, and in the companies you pay when you outsource healthcare IT, and they run your systems for you. These systems and the networks and the configuration is complex, and it's easy to make mistakes. It's easy to not patch as fast as we should. There are often cost constraints and business reasons for delaying security updates because it changes things, it breaks things. And so altogether, it's an orchestration that has weaknesses in it. And so how many of you here in the room conduct, or your organizations conduct, phishing exercises to test your employees and build up resilience? This is something I recommend, 2 things I recommend to help with this phishing pandemic. One is fish your own people. And when they click the link that you send them, it can pop up a training page that says, oops, you shouldn't have clicked. Here's what you should do next time. Look for these telltale clues and signs that this email message was a phishing one. There are services out there that you can subscribe to that will do this for you and give you nice dashboards and reporting. And the second thing, really, from an IT perspective with phishing is subscribe to an email service that will filter and protect you against some of the phishing links. There are several out there that are quite popular, and these sit outside right at your firewall and get all the inbound email. And if there's a link in an inbound email from outside your company, this service will replace that link with its own, a safe link. And so your end user will get the email with a safe link in it, and they'll click that instead. And that safe link will take them to what's called a sandbox, where your service, your email security service, has already gone out and checked the link, the original link, to see if it was good or bad. If it was bad, they'll blacklist it, and you'll be denied access. And if it's good, they'll let you through. How do they know if it's good or bad? They keep lists, and they're constantly scanning and searching, and they pay money for threat feeds that will also update their blacklists with known bad links, known bad mail, and spam distributors, and so forth. All right, so 30%, I like this quote. I have employees who failed every time we have done a phishing campaign, she said. And I'm thinking to myself, how many times is too many? So think about your HR handbook, your employee handbook, and think about folks who are in, now, before I go down this road, a lot of data breaches that I help clients overcome are phishing related, and an employee has clicked a link. And one of the most popular are the W-2 phishing attacks, where an attacker impersonates and I see some smiles out there because this has happened to some of you, I know. Thousands and thousands of companies and businesses, not just in healthcare, have had this happen to them. And you know, as a criminal and an attacker, I can go out on LinkedIn and find out who the CFO is for almost any company. I can get their name, their title, learn a little bit about them. And I can use LinkedIn to do reconnaissance on that organization and learn who is the HR director and who are some of the HR clerks or staff. And then I can find out what their email address is, the naming convention. It's pretty simple. I just need to find one person in that organization's email out on the internet somewhere, and then I copy that format, first name, middle initial, or first initial, whatever. I'll send an email to the HR clerk pretending to be the CFO, and I'll say, hey, quick, send me the W-2 file for 2016. I need it. Thanks. Rob. And you know, 20% of the time they may send it. And if I send out 10,000 of those or 1,000 of those, I've got quite a few responses and I've got quite a few W-2 files, and now I can have a group of my friends. We'll just go over to one of their houses and do TurboTax all day, cranking out false tax returns and getting direct deposit tax refunds. So when you have employees in possession and with responsibilities to process and edit sensitive data, one of the job requirements should be to be resilient to these kinds of social engineering attacks. And if they're having trouble fulfilling their responsibilities in that regard, then it's appropriate to take action, a corrective action plan. And if you have someone who's failing the phishing test every time, that person may need a new responsibility without access to PHI. Okay. So with passwords, I want to spend a little bit of time with passwords because the criminals will trick us into typing our password in where they will be able to see it. Okay, that's the number one way that they get a hold of our passwords. But there's another way that they get a hold of our passwords, and that is through more sophisticated hacking techniques on a company, and they will try to find opportunities to collect passwords as they're being entered by you or your employees. So as you're entering the password and hitting enter, it's going over a network, and if you have a bad actor on the network collecting all the traffic, the network traffic, they'll collect the passwords in encrypted format. And I'm going to spend a little time just discussing this because once you understand how passwords are encrypted and stored, it makes sense how these attackers are getting them. Passwords, when you enter your password for the first time, it's hashed. It's a special form of cryptography that turns it into gibberish, but you can never reverse that. It's a one-way encryption. And that's what's stored, is this hash for your password. And they're stored in these large files, password files. And what's happened over the years is when companies get breached and attackers have taken password files from big companies and small, they've put them out on the internet. And hackers have accumulated these password lists and created voluminous, enormous text files of actual passwords that have been stolen. And they're called dictionary files. And they're full of these hashed password values. Now, if I have a password cracking tool and it has a dictionary file of enormous size, and these will include every word in the dictionary with a 1 or a 2 or a 3 after it, baby book names, so take a baby book and put that in there for everybody's names. Street names, I mean, these criminals are pretty ingenious that way. And before you know it, you really aren't safe using any word all by itself, no matter what the word. And we're also not really safe if the word is 8 characters or less, even if it's gibberish. So we have tricks that used to work well. We would replace O's with zeros and I's with 1s or L's with 1s, things like that. Well, bad guys have gotten smart on that too, and they've written scripts that'll go through the dictionary and replace all the vowels with zeros and so on and so forth. So now, when they steal an organization's password file, if they're that lucky, or if they're able to grab passwords off the wire as users are submitting them, they now have hashes of those passwords, and they will just compare them to the dictionary file, and if they find a match, they know what the password is, because in the dictionary file is the hash and its value. So then they can enter in the password and they're in. It's said that if you have eight characters or less of any complexity, a good attacker with a password cracker and these big dictionary files can crack a password of 8 characters or less of any complexity in minutes, and sometimes seconds. If it's a dictionary word, it's seconds. And so we're now evolving. We have to use passphrases instead of passwords. And we have to have, you know, if we think of a phrase, and I have some examples in a different presentation because I wasn't going to share this with you today, but given the news where we are today, it's important. My son Aiden was 6 years old last November. You know, and you take the first letter or 2 of each of those words and put them together. That's a passphrase. And then you can do the same tricks with the vowel replacement, numbers, special symbols. And that's a good, make sure it's over 12, okay? And you get that mixed case special symbol passphrase. You can pick some seemingly unrelated words. I saw one where a lady had a vacation in Japan, and she drank some sake under a pagoda, and a white swan went by. And so hers was swan red, sake, peace. You know, just something gibberish, but to her it meant something, and she was able to remember it. Last thing on passwords is, this is a little controversial, but password safe. I use a password safe, and some of my security practitioner friends will not use a password safe, because password safe is they can be either file-based or cloud-based, and a password safe that's file-based, you create entries, and it stores an encrypted file on your computer, full of your user IDs and passwords, all encrypted. When you need to look up a password, you open it and look up whatever you're trying to get, and you can copy it and paste it into your login. The cloud-based works the same. You just don't have to worry about having a local file on your iPad and your iPhone and your Mac. Cloud, you just go out there and grab your passwords. The criticism is, well, if I put all my eggs in one basket and an attacker gets in, he owns me. I've got over 200 logins, so do you probably in the course of your life, work and personal and everything else. And so there is a master password to get into your password safe. So mine is, it's 20 characters long. It's a passphrase, and it's complete gibberish to anyone but me. Now, if everybody used password safes, and I can guarantee you the criminals would pivot and figure out a way to attack password safes. That's just how it works. But for now, in 2017, May, I feel pretty safe using a password safe with a really hard master password. And so whether your organization wants to adopt password safes or not is up to you. But I weigh it against the alternatives. I can't remember 250 passphrases that are really hard. I can only remember simple, easy, crackable things for that many. And so for me, given that the chance, I have passwords at Yahoo and Home Depot or Target or Amazon, and so do most of you. And the likelihood that one of those companies is going to get a customer password file taken is high, is very high. And so any password that I may have used there is out and now added to these dictionary files. And that makes it a dangerous password forevermore. So again, I'm trading off risk personally and professionally by putting my passwords in a safe where I can access them and not have an issue. Now, I also trust that the company I chose, who provides me my password safe, this is a company that exists for the sole purpose of keeping my passwords secure. It's not like Home Depot, whose sole purpose is to sell me hammers and saw blades. So I'm not as worried that this company is going to skimp on security, not hire good security people, because their existential risk to them is to get hacked. So those are some of the factors I've thought of when trying to solve this horrible conundrum of passwords. If you do go down that path, make sure you have a policy for how you're going to use and implement a password solution, and make sure that folks are trained. And a lot of companies right now are saying no to password safes, but encouraging employees to use them outside. Some companies are buying a licensed enterprise-grade password safe and deploying that solution along with two-factor. So anyway, it's a debate. Okay, any questions so far? Let's go into the slides. What I want to talk about after these current topics today really is risk assessments. And I've had the opportunity to help a few clients post-data breach, post-PHI loss, and the OCR has come in to investigate what happened. Every time, without fail, the OCR will criticize the covered entity for failing to have a documented and valid risk assessment. And so I think we've caught up. I think we've caught up as an industry somewhat into understanding, comprehending, and doing risk assessments better. But it used to be a lot of consultants out there that would sell HIPAA risk assessments were not doing risk assessments. They were doing gap assessments. They were doing compliance assessments, and they're different. They're not all created equal. Okay, so here are a few recent OCR actions against covered entities for HIPAA data breaches, and you'll see a familiar theme here. This year, a $3.2 million fine to a covered entity. They lost a BlackBerry all the way back in 2010. They're just now getting their fine. Okay, that's 7 years. 2013, they had another breach, a lost laptop with unencrypted PHI. So the incident in 2010 probably wasn't enough to spark a fine, but when you have multiple incidents over multiple years, it's going to get you on the naughty list with the OCR. Lack of risk management plans, no encryption on mobile devices, and poor physical access controls. Not everything is cybersecurity. I know it's ePHI, but this particular covered entity had mobile devices in the clinical setting, so healthcare providers could be mobile and quick with the patients, and they're taking in data and processing it. But then at the end of the shift, they would check their mobile device, their tablet, back in to a locked room. And they had no record or log of who would come into that room and take a device. Okay. This is one, again, this is this year. This company, this healthcare organization was told by the OCR and given a chance to plead their case. In the administrative process of an OCR investigation, you have a chance to make a defense. And this covered entity did not take the OCR up on that opportunity to put up a defense or rebut the claims. Okay, so in this fine, which is $3 million, and this is a small covered entity. They only had 3 clinical settings in one state. So a $3 million fine was a big chunk of their annual operating budget. The OCR cited aggregating factors when they levied this fine. Continued use of unencrypted devices for 5 years, and they had a prior history of noncompliance. They also had reportable incidents, 2008, 2009, 10, and 13. Okay, so don't think the OCR wouldn't levy a big fine because you're small and it might put you out of business. and there have been plenty of covered entities that had incurred multi-million-dollar fines that were quickly bought in a fire sale by someone else. Here's one from this year, $2.2 million fines. This was a stolen memory stick with encrypted data, unencrypted PHI on a flash drive. And so I ask folks, do you have any unencrypted PHI on any mobile device, anywhere for any reason? And if so, why? And there may be good reasons for that, but I haven't heard them yet. Not in this day and age, not with the risk of loss and the size of the fine that you'll incur. I believe the OCR's lost patience. They're saying to all of us, if you have unencrypted PHI on a mobile device, a laptop, a tablet, or a flash drive, anything, and you lose it, it's going to hurt badly. They're sick of it. And I sympathize with them a little bit because it's reasonable to procure a solution that will encrypt this data when it needs to be mobile. All right. This breach was also exacerbated by failure to conduct a risk analysis. And so I want to just dive in right now into what comprises a risk assessment, risk analysis that would be suitable and appropriate to the OCR if they came in after a breach and asked to see it. It's one of the first things they're going to ask to see. I can hear my mic kind of coming in and out, so I'm gonna try to hold it up a little closer, and this hopefully will help our folks on the webinar. Is that too loud? Okay. All right. Here's some more. Again, these are all this year. $2.5 million. This one I said, hey, how much money would it take to improve your security program today before a breach? What could you accomplish with $2.7 million, right? Let's take a third of that. Let's grab $700,000. We could get quite a lot of improvements made for that. And so part of the challenge we have is helping the bean counters understand what can help and what's reasonable in light of the risks we face. And one of the best ways to do that is to conduct a risk analysis and show them with data that they can understand and comprehend and hopefully turn that ship and get a little bit more funding where it's needed. All right, so when I look at the OCR penalties this year, here are the common threads. Missing or outdated business associates agreements, a poorly conducted risk assessment, failure to encrypt on mobile devices still, failure to notify breach victims timely, and this is crazy to me, failure to even respond to the OCR when they send you a notice of investigation. It happens. Okay, so here is 164.306, and I want to show you that, we talk about the objectives of security rule, the confidentiality, integrity, and availability of ePHI, and protect against unauthorized uses or disclosures. I want to point out the flexibility of approach, which we all know about, hopefully we know about, but this is a dual-edged sword because it can create ambiguity and it can make it difficult to know what applies, but at the same time it allows us to be flexible and justify decisions to act or to act in alternative, cheaper ways that are less disruptive. And we'll talk more about that. Okay, so 164.308, security management process. This is a overarching risk management function for the IT and the physical security of ePHI. Subordinate to that is the risk analysis. So a piece of the security management process is the risk analysis. The key words here are assessment of the potential risks and vulnerabilities. This microphone is driving me nuts. All too often when we have a poor risk assessment, it's because the people that created and performed the risk assessment failed to understand the key ingredients. The ingredients include vulnerabilities and likelihood and impact. So I want to walk through those. This is a snapshot of the NIST standards that the OCR puts out there for us as guidance on conducting a satisfactory risk analysis. They've got 3 standards that deal with varying components of the risk assessment and risk management process, and I'll show you some snapshots of those here in a moment. The security rule also requires documentation of your risk analysis, and so maintain in written form, and that is often overlooked. And I'm just pointing out that when you do your risk analysis, you want to make sure that you have some kind of a documented record of doing it in a way. And I like these Gantt charts that I'm showing. You know, it can be as simple as this: a risk assessment project Gantt chart with phases: system, documentation, risk determination, control selection, and monitoring. So a simple step like that of just keeping a project plan in place that's continually refreshed over the year, that would suffice for mapping, documenting your risk assessment activities. So if we start here with a risk analysis, we do that activity, we obtain our results, we choose our safeguards, we choose which addressable implementation specifications we need to include, and then we provide those into the risk management apparatus. Risk management, compliance officers, and so forth. So the risk analysis is often done once a year, for example, and it's a point in time. What happens during the other 8 months, 9 months of the year between the time the consultants come in, do a risk analysis, and leave? Risk management is an ongoing process, part of management's regular monitoring of compliance and risk. And so we want to make sure that it's not just one and done and forgotten. We don't want to create risk analyses that are shelfware, that delivered in a binder and go in the bookcase in someone's office. I've seen that a lot. And they pull it back out next year and open it up and pay a consultant to update it, and then they close it and put it back on the shelf. Don't do that. Okay, so the NIST standards, love them or hate them. OCR will tell you if you're a small or medium-sized covered entity, the NIST standards may be overkill, and you're not required to implement the NIST risk management standards in full or even in part, but they're guidance. They say right here in their FAQ document, some of the documents may not be relevant to small organizations as they were intended for larger government organizations. And these risk management standards are the same ones that underlie federal information systems, compliance, and risk. So the 3 that I wanted to introduce today, and you may have had some experience implementing these, are 800. This is the NIST Special Publications Series 800, which is all about information security. A famous one is 800-53, which is 480 pages of detailed security controls. And so let's walk through these. This one is 39, and this is the highest level. It's titled Managing Information Security Risk. I just wanted to show you, I just took this snapshot out of that document. So if you were to read 800-39, you'd see this picture, and you'd read a detailed description and a bunch of definitions about these phases or these activities. And I just use this as a starting point because it gives us a place to look and say, look, what kind of operating environment do we have here? What is risk to us? So healthcare, PHI. We know from our years of experience what our operating environment is and what the risks are that we know, by and large. And so we now have a question of how do we assess those risks? How do we determine which risks are worse or better, which are more important? How do we prioritize? Once we've prioritized, how do we address the risk, respond to it, transfer it, mitigate it, so on and so forth? And then lastly, how do we monitor those 10 months of the year between risk analyses? How do we keep an eye on key risk indicators that when they spike, we jump back into action and we focus in and address it? And we learn that from, look, we have the dark overlord acting up and dumping 1 million records or 800,000 records. Is there any indication of where it came from? How was it obtained? You know, so we're keeping our eye on the threat environment. We look at security blogs, the media reports, interviews of security researchers that will tell us clues about attacks, techniques, attribution of sources. You know, is it North Korea? Is it an organized crime ring in Chicago? So on and so forth. Are there sectors or groups specifically aiming at healthcare records? If so, are they predominantly going through phishing attack vectors to get this data, and so on and so forth? So that's the kind of question and answer that we're engaged in throughout the year. The next standard is the risk management framework, which is a way to conduct your risk analysis inside a larger risk management framework. So your risk analysis can be point in time, but plug into this risk management framework that never ends, cyclic. The third standard, and I'll go back to this one, the next slide here is the actual act. So let's look right here. We're gonna take step 1 and 2 on this standard, and this is blowing it out in NIST 800-30. So this is the lowest level of the 3 standards I showed you. It's the actual process by which you would do a risk analysis. Okay, so coming back to this diagram I showed you earlier, the NIST 800-30 helps you conduct the risk analysis, and 37 and 39 give you a blueprint for the management structure and the processes that management structure undertakes on an ongoing basis to take in, internalize, and react to the data produced in this risk analysis. The decision-making that comes out of this process includes funding for IT security. What product, what service do we need to budget for? And this should be a 3-year roadmap. Identifying your weaknesses, and we all know we can't just run out with a blank checkbook and buy all the security products offered today and try to cobble them together and be secure. Meanwhile, somebody's getting phished and it still results in a data breach anyway. But what we're trying to do is take the long view. We're creating documentation and defensible process that we show the OCR should we have an investigation. And it does derive value in terms of helping management understand what the needs are, what are the risks, and how should we budget quarter by quarter to buy things like a secure email gateway that will help reduce our phishing risk. Or we need budget to pay for a Phish Me Now or a phishing service to help train our employees. And we need to do more than just that annual poster in the hall or the annual webinar that we've all taken. So to get into the meat of a risk analysis, we want to be clear on our definitions. And some of these definitions are called right out in the regulatory language. The vulnerability, okay? A lot of people will confuse vulnerabilities with threats. Vulnerability is a weakness, a soft spot, a way in, an unlocked door, a gullible employee. It's a condition that exists that a threat will walk through and exploit you. The threat, oftentimes we think of these as humans, but they're not necessarily always human actors. Threat can be threats to availability can be system outages, power disruption, natural disasters, so on and so forth. And luckily, we have some models and some guidance from those standards to help us sort through identifying vulnerabilities, identifying threats, and then putting them together in foreseeable ways, in common sense ways. So the risk, and again, we have the government language here, the net mission impact, you know, that's military speak for a result. The result, when we consider that a particular threat will exercise or take advantage of a vulnerability, and a bad thing happens. The probability that that happens. So this is where we have a pretty big diversion in risk management in the world today. There's financial risk management and quantitative risk management, and then there are areas of risk that aren't so easily lent to adopting quantitative risk techniques. So there have been many information security professionals that have tried to adopt quantitative risk measurement and risk analysis, and the results are kind of across the board. And some information security professionals would say it's foolishness to think that we can use mathematics and actuarial science to manage cyber risk. But there are others, namely insurance underwriters and some prominent security pundits that say it's possible. And so I leave that for you just to be aware that that condition exists. But don't forget that the regulatory language says we have to do a risk analysis. And so whether we attempt a mathematical one or a qualitative one, which uses red, yellow, green, high, medium, low, 1, 5, and 10 to score things, you know, just be aware that there are different options. And if you're a quant, you can go get a quant solution. And if you're not predisposed to that, we're more likely, like the rest of us, who trend over in the qualitative side of risk assessment. Okay, so I simplified these definitions for us out of the bureaucratic speak in the NIST standards. So we have vulnerability, a flaw or weakness, a threat, a potential of a person or thing to exercise a vulnerability, and the risk is a combination of the two coming together. The likelihood or our expectation that it's more reasonable than not that the two would come together in a way that hurts us. And you can use language that fits you and your organization. But I would have these things decided on as an organization, and I would probably put it in a policy somewhere. It could be a risk management policy. And in that risk management policy, you've gone and defined the governing committee of your organization and their role with regard to compliance and risk acceptance, risk transfer, risk mitigation. So these are the ones who get paid the big bucks and have to make the hard decisions. And then down below, you might have a defined risk and compliance committee that takes care of the kind of the middle layer. The lower risk stuff, you can make decisions and authorize spend and identify the big rocks that need top management's attention. Also in that policy, you might adopt some kind of basic risk management technique or philosophy. You might state that we prefer to use some of the techniques we're going to talk about today. You might say we like an octave. There are different risk management frameworks out there that you can adopt. There COBIT has a risk management framework. We have octave. There's the NIST standard. You could adopt that one, and you have choices out there. The key, regardless of what risk management framework you choose, is to address vulnerabilities, threats, and the resulting risk, and impact and likelihood, and we'll get to that next. So when I'm doing a threat assessment, again, we have human threats, natural threats, and environmental threats. Vulnerabilities, the weaknesses, There are millions of them. They exist everywhere. And you really can't create a modern IT system without it being accidentally riddled with weaknesses. Riddled maybe is a strong word, but it's very difficult to produce a pristine, clear, clean, totally secure system. It's not going to happen. So these vulnerabilities, they exist in the technology. Mistakes made during software development. Mistakes made by IT administrators when they configure the pieces of the layers of your modern IT, EMR, your medical record system. People are vulnerable, as we've talked, and processes have weaknesses. Vulnerabilities can exist in all three of these. Processes can produce, like I mentioned earlier, the hospital that had the check-in, check-out iPads. The process was flawed because it did not account for an audit trail or access authorization to go in and get it. So I'm going to come back to this slide again and add to it. So we have our risk analysis and our working within our risk management framework, and it's driving the control selection, the safeguard adoption, budgeting. So these are the steps from NIST 830 here under risk analysis. There are 8 of them. And so that's a roadmap for conducting your risk analysis. Over here is just the high-level components of your risk management framework as found in 837. And just a nod to the safeguards, we have administrative, technical, and physical, and that should ring familiar to all of us. So I'm just trying to give you the bird's eye, the 50,000-foot view here of how the risk analysis fits into everything else. So when we look at a risk analysis, if we're going to go back to work, we're going to take a look at what have we done in the past by way of complying with HIPAA to do a risk analysis. And take a look and see what your past reports look like. If you've done one, who did it? How did they document it? And look for the key hot buttons. Did it account for threats, vulnerabilities as a way to derive risk? And for those risks, did it account for the impact and likelihood of those risks? If you find that it's flawed, it's maybe missing some of those components, then you set a goal, get your stakeholders together, and go through some of these guidance documents and then work to improve it. There used to be quite a few HIPAA consultants out there that would sell you a HIPAA risk analysis that really wasn't. I did a check this morning, and I was pleased to see that there are quite a few of them. So when you're shopping for help and you want to hire a consultant to come in and do this, make sure that they at least address these necessary ingredients. Okay, I'm going to think of this as a risk analysis recipe, and you must have these four key ingredients. Okay, so we're going to talk now, we're going to start right out with what's the scope of our risk analysis. And we need to know all of our EPHI. Where is it? We can't protect it if we don't know that we're getting it. How are we getting it? At what point in our business operations is EPHI introduced to us as a business entity? Look far and wide. You may have to conduct interviews and dig up. One of the resources maybe is your auditors or your internal auditors. And I think a data flow diagram is almost necessary in any organization of significant size because of the number of complexities and operations. You know, we're here at St. Augustus, and there are multiple departments. It's a large, sprawling complex, and there are a lot of operational units going on here. And some of them are going to be running software that's unique to their function. You know, the radiologists have their favorite system, and orthopedics has a different system sometimes. So a data flow diagram for EPHI should accomplish three things. How do we receive the EPHI? Where is it stored and transmitted? Okay, that's kind of the second, storage and transmission. And third, when does it leave us? How is it leaving? Okay, those are the three. And it's basic. Any information system is going to take input, process data, and spit it out. Okay, you got to gather data, gather up all the resources at your disposal to help you identify the scope. Here are some places to look. Do you have, I know this is facetious, do you have an inventory of your PHI? If you do, obviously start there, but a lot of organizations have not done this. This is pretty hard, creating inventories. Modern information security best practices call for inventorying your sensitive data and inventorying your systems, right down to the individual component, databases, web servers, application servers, network gear, so on and so forth. You buy them, you know, they have life cycles, they need to be replaced, all these things need to be maintained, and so the lazy man's approach in IT is to just blast a patch out to anything that responds to being a Cisco router, right? Or we deployed that network gear in a way that it's going to phone home to Cisco and automatically be updated. We don't know how many there are, but our job is to just put them out there and make sure they work. I wouldn't let IT off that easy. I want a list of every Cisco router, every firewall, and if you don't have one, we need one. You know, we need one for risk and compliance purposes. And that's a factor, that's a situation that should go to that risk committee and talk about it. And there are resources out there to help you bolster your case. The CIS 20 Critical Controls, Center for Internet Security, I'm going to write this one down, Center for Internet Security, 20 Critical Controls. The first two controls, these are the top 20 things, technical controls, technical safeguards, if you will, that make the most difference in not getting hacked. Guess what 1 and 2 are? Inventory your software, inventory your hardware. Okay, as you go about assembling inventories, you're going to be talking to a lot of people. You're going to need maybe to get some tools that scan your environment and have your IT folks scan the environment for all of the different servers and devices that are out there. So there's no time like the present to start, you know. This would include outsourced services. Now, you're not going to go into Amazon Web Services, a big cloud provider, and scan them and inventory them, but you are going to inventory what you are causing to be created out there. So if you're going to have a database and a web server for a messaging system on-premises here, and you decide to migrate that to a cloud provider, you're at least going to have an inventory of that service and what it's composed of. Yes? So the comment is there are a lot of medical devices that are sitting in our clinics, in our space, that are not deployed by IT, and they are what we like to call shadow IT, where businesses, I'll use businesses as an operating group, a healthcare delivery function, can go out and buy products that help them administer their services. Medical devices, you know, you have the type 1, 2, 3 medical devices under FDA regulation. There's a lot. The FDA just released their cybersecurity guidance for post-market deployment and management, cybersecurity management of those devices once they're sold and implemented. A couple of years ago, the FDA released the pre-market guidance. So that was aimed at manufacturers, distributors, and buyers of medical devices, you know, especially type 3 pacemakers. And we may have heard some of the news that, you know, can you imagine getting your pacemaker hacked? Can you imagine ransomware? Hey, pay me 100 Bitcoin or I'm going to turn your pacemaker off. Okay, that's coming, if not already here. And so the FDA has this guidance, and it talks about what we do to manage the cybersecurity risk of those products. So don't limit it to just what IT does. I guess that's what you're saying. You need to interview the operational units as well to find out, have they gone and subscribed to a SaaS product, software as a service, without IT even knowing? So that happens. Okay, step 3, identify and document potential threats and vulnerabilities. Again, these are the 2 big ingredients that are often overlooked in risk analysis. Threats. When we're talking about human threats, I like to use an acronym called SCRAMO. This stands for skills, knowledge, resources, access, availability, motivation, and opportunity. Those are the attributes of a human being, of the human being's ability to hurt you, okay? If all of those are 0, they're not a threat. If 4 of those are really high, that's a formidable threat. In your analysis, you may want to score threat actors based on these. And in the end, you can prioritize by that score. You may have unintentional mistakes by someone who has really high access and they're authorized, but they have no motivation or objective to do something bad, but they've got the access here, the resources. So that's not a low risk. It might be a moderate. Maybe in your organization that's a moderate risk. In some cases, a high risk. In addition to our own people, our insider threats, we call them, and we think of insider threats as malicious or intentional, but we also have insider threats that are accidental, like the employee who sends out the W-2 file or discloses patient records unknowingly. You have nation states kind of at the top of the threat spectrum, the biggest and the baddest, all the way down to organized crime, hacktivists, opportunists. And don't underestimate or overlook the hacktivists. In other industries, this flares up with government, of course, religion, even GMOs, genetically modified foods and crops. There are people who believe that that activity could destroy the earth, and they're going to go hack those companies and cause them a lot of pain and suffering to disrupt their operations. These are people that have they feel a moral duty to disrupt what they determine to be bad business practices. Okay, healthcare setting. We have that in a lot of areas as well. Politically motivated attacks, so forth. Okay, now vulnerabilities. So that's how we would do a threat analysis. Again, I mentioned earlier keeping up with the news, subscribe to your favorite blog, security blogger. Brian Krebs is a great one. ARS Technica, Wall Street Journal, I like their reporting on cybersecurity. But we have a readily available source for free, and you can actually pay for some really good ones that are custom to healthcare of emerging threats and trends. Some of that information is better consumed by your IT people. Some of it's better consumed by your risk management and compliance folks. Now, vulnerabilities. How do we find these weaknesses? Again, we have weaknesses in technology, in process, and in people. So technology, vulnerability scanners are devices that scan your network. They will scan a server. They can scan a database and report back where there's weaknesses, misconfigurations, missing patches, default credentials still in place. So we should be scanning our environments regularly. You can scan from the outside, like an attacker would, and you can come in on the inside of your organization and scan around on the inside and find a lot more vulnerabilities. It's like the hard shell on the outside and soft inside. You want to do both periodically, and you want to have a vulnerability management policy. What's our policy for updating and deploying critical patches? Vendors release patches with criticality ratings, low, medium, high, or critical. And so you want to have a goal to deploy critical patches within a certain time frame that's reasonable and not be caught flat-footed with a critical patch that was released 2 years ago and you didn't patch. And therefore, when a WannaCry ransomware rolls around next time, it gets you, okay? So that's one way to find technology vulnerabilities. You can find vulnerabilities in code with code scanners, and developers will or security professionals can use for web application vulnerabilities. Again, this is more IT speak, but the tools are there. You should have a process for searching for these vulnerabilities in the technology. Don't confuse vulnerability assessment, which I call a vulnerability scan, and the reaction to the scan results and assessment. But a vulnerability assessment is not a risk assessment. Vulnerability assessment finds vulnerabilities, which are an ingredient to a risk determination, but don't try to take a vulnerability assessment and pass that off as your risk analysis. Likewise, don't think a penetration test where the good guy hackers come in and try to hack into you. That's not a risk analysis under HIPAA either. And a lot of organizations try to take those and pass them off as their risk analysis. I'm jumping ahead to another slide, but the third thing that is not a risk analysis is a gap assessment. Don't take a list of all the implementation specifications from the HIPAA security rule, put them in a spreadsheet, and then check yes, yes, no, no. Next year we'll have that one. That's not a risk analysis either. That's a gap assessment or a compliance assessment to the safeguards, but you didn't look at threats, you weren't looking at vulnerabilities, you weren't determining likelihood and impact when those cross, and so that's not a risk analysis either. How do you find vulnerabilities in process? Ask your people. Your line workers are going to know. Remember the famous story where one of the airlines had a suggestion box and someone in maintenance said, hey, if you backload the plane first, you'll have better gas mileage flying through the air. And they did. They saved millions of dollars on fuel costs because an employee down in mechanical said, for half-full flights, load it back heavy. You know, they never would have come up with that had they not opened up the suggestion box. Right now, there are people in your organizations that can see big vulnerabilities, and it bothers them, and they just don't know who to tell, and they don't know that if they did tell, would they be in trouble, would they be appreciated? So that's something to consider in risk analysis management. All right. Again, with people, we assess their vulnerabilities, one, by testing them, giving them these phishing tests, and it just depends. You know best how to assess your people's knowledge. Sometimes we might have internal security programs where we have certifications. I've seen these work well in banks. And if you're on the webinar, we just have a beeping phone on the wall. We're trying to get it answered. And I'll just keep going here. So we have options on how we score and rate vulnerabilities. And I say don't reinvent the wheel. There's already a very reputable system out there for scoring vulnerabilities. It's down here at the bottom of this slide, the Common Vulnerability Scoring System. I gave you a link. You can go look at it. And it's utilized by two resources that are very popular, the CVE database, which I think I have on the next slide here, Common Vulnerability and Exposure Database. It's run by MITRE.org, M-I-T-R-E.org, and it's the CVE database. For example, WannaCry ransomware that we heard about in the last week exploited CVE number, and I don't know the number off the top of my head, but its vulnerability that it exploited was listed in the CVE earlier this year when it was revealed after someone stole it from the NSA. So here's some of the factors or scoring for a vulnerability, okay? You might want IT help with some of these, but not all of them. What's the attack vector, okay? How does that threat agent get through the vulnerability? Does he have to be standing right next to it, walk into the data room where the iPads are and pick one up and leave? Or can he do it from Ukraine? Okay, that's the threat vector, or the attack vector. How complex is the attack? The WannaCry ransomware attack was fairly sophisticated. The code needed to exploit the Microsoft vulnerability and inject the ransomware was not trivial. User interaction. Did someone need to help facilitate? I'm just looking up here at our console to see if there's any warnings that someone's making this. Yeah, maybe there's a hack going on and beeping at us. Let's see here. All right, I'm not going to go through all of these. I just want to give you a view here. One of the big factors in whether a vulnerability is critical is whether someone out there wrote code to exploit it or not. So some vulnerabilities aren't as bad because no one knows how to go through them yet. All right, assessing your security measures. This step of the risk analysis is what we're talking about when we do a gap assessment. So you consider those controls that you have in place and you audit against them. Are they working or not? That's the question you're asking. So think of a safeguard you have for preventing phishing. What's your safeguard for preventing phishing? Training and awareness. Is it effective or not? If Janet is clicking every dang time, it's probably not effective, at least for her. Now, if you have 80% of the people that don't click your phishing test, that's pretty good. What about that 20%? Maybe you carve them off and you hit them again and again until they're a little bit better off. All right, let's get through this a little further. And these are the techniques that an auditor, a CPA firm, will use to assess safeguards and controls. The key on tests of design and tests of effectiveness are I won't get into the details, but how many of you have heard of SOC reports for third-party risk management? So if you outsource IT to a third party, they may have an auditor's report, SOC report, where an auditor went in and said, hey, the security controls are good. If it's a SOC 2 report, that's for IT outsourcing. SOC 2s have two types. There's a type 1 and a type 2. It's a little confusing because you've got SOC 1, SOC 2, SOC 3. We're just talking about SOC 2 for IT outsourcing. And there are two types. Type 1, the auditors did tested design at a point in time. They just looked at the controller safeguard and said, it looks designed properly. If it's a tire, it's round and it rolls and it holds air. But they didn't assess the control the way they would for a type 2, which is over 6 months or a year. And there they gathered data to show that, yeah, that tire's been full and rolling and withstanding potholes for 6 months. All right, this is the hardest part of risk analysis for most of us. How do we determine likelihood? I don't have a crystal ball, and yet I'm regulatorily mandated to determine likelihood. Okay, so I pulled this one. This is an impact. So coming back here, let's look at impact first. I pulled this out of the FDA guidance on the cybersecurity guidance for medical devices. This is how they wanted healthcare organizations to do impact analysis. And again, if you're dealing with a type 3 medical device, here's the impact. And they've spelled it out in 5 terms. You can use this model. You can have 3 terms, low, medium, high, whatever works for you, okay? But make sure that in that policy I talked about where you've defined accountability and organized your risk management function, you pick your risk methodology, make sure that you lay out your impact criteria. What are you going to use? 1, 2, 3, low, medium, high, red, yellow, green. More importantly, what do they mean? Okay. Here's how we can determine impact dollar amount. Another way, cost per breach record. There are reports out there that say, you know, one record's worth $100. Not so much on the black market. but the breach of one record will cost you $100 per record in legal fees, compliance costs, forensic examiners, so on and so forth. It's probably closer to $200–300 per record. Unless, yeah, I think that's about right today. Okay. Back in the financial crisis, when Wall Street blew up and all the banks almost failed, they were selling mortgage-backed securities. And that was an invention of a Wall Street quant. And there was a Wired magazine article about that person and his formula that was the backbone of the mortgage-backed security derivative product. And this is a greatly simplified version of that formula. And it was on the cover of Wired magazine in February 2009. And I like it because it demonstrates to me the fallibility of quantitative mathematics in determining future risk. One of these variables in the formula was meant to hold the probability, a number between 0 and 1, that the underlying securitized asset would decline in value. And that was our houses. And in this formula, the likelihood that our houses would decline in value in 08 was really low. And so they plugged in a number near 0, and it made the formula work. Until what? Until our houses started going down in value. And then everything just blew up. And so I put this out here as a warning against getting too quantitative, too fancy with your math. And I've seen some pretty interesting algebra used for some of these risk analysis. So we can rely on our experience. We can rely on education, experience, and reasonableness. We don't have to have a crystal ball and accurately predict the future. What we have to do is show the OCR that we sat down, we talked about it the best we could with what we exercising judgment, and we've documented it. And that's enough to get a pass on your risk analysis. You don't get penalized for being wrong or being a poor judge of risk. You get penalized for not doing it, okay? So we've looked at vulnerabilities, we've looked at threats, we've tried our best to anticipate the likelihood of certain threats exposing certain vulnerabilities, and we've determined the impact. We've done our best to say what's going to really kill us and what's going to be a speed bump in the road. And then you plot them out on a chart like this. You've all seen these before. These aren't very, the quantitative folks don't like these, and they say that they're bad and they create more risk than they're worth. But this is what the OCR prescribes. This is what the NIST standards prescribe to do. And so I recommend that we include them. Here's another one I got out of the FDA guidance I keep referring to. I like this one because it shows, hey, not everything's black and white. There's shades of gray, right? And you can plot your big risk items on something like this, going up to a senior risk committee with your top 5 risks. Okay, you know you're only going to get funding for 3 of them. You know, so you throw your top 8, and you say, here's how we decided to recommend to you to fund X number of dollars for this package of systems and controls and new hires, because we analyzed the risk, and these are the top 3. And we derived that decision because we looked at the vulnerabilities, here, here, and here, and we have all the data if you want to see it, and they probably won't. And we assessed the people, we interviewed people, we got their experience, we got their suggestions, and we as risk managers and IT people, we came together, and this is how we are presenting it. Okay, I've already talked about this, what's not considered a risk assessment, gap assessments, list of threats with controls next to them, follow all the steps, include those ingredients in the recipe, and the big ones, threats, vulnerabilities, and likelihood and impact analysis. Okay, common mistakes. One is not doing it at all. Second big mistake is failing to consider shadow IT, which is organizations or operating units going and getting their own IT without IT knowing and paying for it on their own.
lack of inventory. You can't secure what you don't know about unless you're lucky, and we're all lucky sometimes. We know that. And not engaging upper management in explaining what's required of us, how we're going to approach it, and then letting them know that when we're done, and letting them know, hey, we're going to do risk analysis better this year based on maturity, and it's going to result in some increased ask. Question?
So in a situation where you have a covered entity that's outsourced IT, is it sufficient to ask for a SOC 1, SOC 2?
Oh, yeah, absolutely. Well, the question is it sufficient to ask for a SOC 2 report for an outsourced IT function at a covered entity? Don't accept a SOC 1 report for HIPAA compliance, because a SOC 1 report covers controls over financial accounting, financial reporting. There will be many vendors out there who will give you a SOC 1 in hopes that you will go away quiet, because they don't want to pay for a SOC 2 and a SOC 1. But they're public, so they had to get the SOC 1 first, public company. Ask for a SOC 2, review it, document that you reviewed it, see if there's any considerations in the report from the auditor, because sometimes there's a weakness or two that they highlight, and then document that you're following up with that service provider to get reasonable response on what they're doing. Here's another thing to do with your outsourced IT service providers. Okay, I'm going to jump ahead because we're out of time. I just want to say that this is a security risk assessment tool that the OCR gives for small and medium organizations. If you're not doing anything, use this. And if you've done your own and you didn't do the things we talked about today, start with this, because you're not going to get in trouble by using this. I don't know that this is extraordinarily helpful, because all this does is take the regulatory language, chop it up into a million pieces like sushi, and then it just gives it to you like that. But some of you may have comments on that. We can talk about that offline. Here's some action items. And I talked about this earlier. Go back, look at your last risk assessment, your risk analysis. Consider your methodology. Find out if it has the key ingredients. Get help if needed. Budget and get a consultant or someone who does these regularly to come in and guide it. Sometimes you can get it for pretty cost effective if they just are the project manager and you have some worker bees doing some of the heavy lifting. Okay, work on your inventories and then have a goal in 1 year. We're going to have an improved risk analysis, and that will drive some recommendations to management for change. Okay. Again, we're out of time, and if you want to drop off on the webcast, you may do so now. I'm going to do just 2 more slides here in closing. Okay, this was a picture of WannaCry. When we talk about third parties and outsourcing IT to IT service providers, oh, my slides didn't get in. Okay, I have a slide that I went and I Googled top 10 EMR outsource providers or service providers, EMR, e-medical record systems. And I found a website and it had a nice picture of the top 10. And you've heard of many of them. I'm not going to name them, but I encourage you to do this. Google top 10 EMR vendors and get that list. Then go back to that CVE website. You can go to CVE or you can go to the National Vulnerability Database. It gives you the CVE data in a more user-friendly fashion, okay? Just Google National Vulnerability Database. Go to the website, plug in the name of your vendor, and see if they have any publicly disclosed vulnerabilities in their software. 2 of the 10 did. I did this yesterday. 2 of the 10 had some significant vulnerabilities published in this database. 1 of them has a really nasty one, and it's 2 years old. And so that's one of the steps in your risk analysis is you're looking for vulnerabilities on your outsourced IT. I would call your vendor and say, hey, I just noticed in doing my HIPAA risk analysis, doing vulnerability assessment, that you have some documented vulnerabilities in the National Vulnerability Database. Is this true? What's your plan for fixing it? So on and so forth, okay? I'll go further and give you some quick stories in closing. I was asked by a client to go assess their EMR provider. It was a relatively small provider in a niche area of healthcare, but pretty successful, had 600 paying customers for the SaaS software, patient management system. They had signed 600 business associate agreements with all their customers, and we went in to assess them for HIPAA security rule. If I could have scored them an F-, I would have. It was horrible. Their data room was in an abandoned strip mall in a bad part of town. And they had a firewall, and they used passwords. And that was all I could find. That was it. 600 customers, some of them really big. It happens. It happens. And so the second story is I had a client who has a very popular EMR system outsourced, and their patients' data was being altered. And they didn't know how or why. And come to find out, after a lot of hair pulling and investigation, there is a very nasty vulnerability in the way the company that they're buying the service from architected the support so that the support people can come in and administer and fix stuff when it breaks. And an attacker had taken advantage of that configuration and come in and set up shop. And so it happens, you know, by doing these kinds of risk analyses and exerting this kind of due diligence, looking for vulnerabilities and scanning, do the pen tests, do the vulnerability scans, do these risk analyses. And you're never going to find everything. But when we have an incident, we want it to be a fender bender and not a head-on collision on the freeway. Okay, there's a big difference in our future after one versus the other. And so look at, you know, break down those barriers with your IT folks, talk about those 20 critical controls. Don't think that the HIPAA security rule safeguards are all that you need to do to keep it safe. And I know I'm running long, I'll give you one last thing. NIST cybersecurity framework is mapped by the OCR to the security rule safeguards. You won't find that mapping in the informative references when you get the cybersecurity framework from NIST, but if you go to the OCR website, they have a copy of it where they've added in security rule references. So just a little help. Fix your risk analysis, use that cybersecurity framework, and make sure that someone in your organization is looking at those 20 critical controls along with the specified safeguards. And I think you'll be in a good position for fender bender activity and no head-ons. Okay? Sorry I ran over. Thanks for your time.